I have mentioned earlier, WTC 5599 by 2019, that is the Rehabilitation Matter under Land Action Act. And about 20 times it has been listed what it could not be disposed of. And the WS they have filed, a date back highly fixed.
This is a government land settlement matter.
Quickly list item number 1.
No, the item 1, I'm filing the counter affidavit for occasion. Added to the last date to clarify as to whether that question number 5A it has been evaluated or not. Or should that I'm filing the affidavit. Para 7 of the affidavit. It has been
Yes.
para 7 of the affidavit, page 3. It has been evaluated.
Page para
7 minutes, page 3.
Please read it out.
My lord. In reply to the averments made in so and so, it is humbly submitted that the petitioner has advanced his contention and alleged that in law property paper, the question number 5A has not been evaluated by the examiner. In this connection, it is mentioned herein that the concerned examiner has made tick mark on the question number 5A and question number 5B. Hence, it is obvious that the examiner has read and examined the answers thoroughly and finally awarded 4 marks for the question number 5, and the same mark has also been posted on the front page of the answer script. This is relevant, my lords. Hence, the total marks secured by the petitioner in law of property paper is, that is 53, is correct and proper. Regarding improper marks is secured by the petitioner in other questions of law of property, it is humbly submitted that the marks awarded by the examiner after thorough evaluation of the answers given by the petitioner, and it is solely at his discretion. My lord, if your lordship may see the writ petition, page 29, my lords. All the marks, my lord, that were evaluated has been, my lord, mentioned on the front page of the answer script.
Writ petition, page number
29, my lord.
Okay.
Lordship, towards the last, it is slightly illegible.
Page 29, annexure 4.
Annexure
4
6, my lord.
page 29.
Annexure 6, page 29.
Annexure 6.
My lord. So, my lord, last question number 5. Question 1, 2,
No,
3, 4.
you just read that instruction to the candidate.
My lord.
সেই পেজটা পড়ন্তু পুরো পেজ 20
Check the
পড়া গেল আচ্ছা
answer book. Check the answer book, if I may.
না না ওপেন ঠিক আছে পড়ুন
Check the answer booklet thoroughly, which contain 64 pages, including 4 pages of graph. Before filling in the details, the defective answer booklet.
Please adjust the mic.
The defective answer booklet may be reported to the invigilator for replacement. Please write your roll number, subject code in the specified boxes and darken the circles corresponding to your roll number and subject code. Write the details of your particulars, that is name of candidate, name of examination, post, date and sitting of exam, and name of exam center with zone in part B of OMR sheet. Ensure that the OMR barcode sheet is properly secured to the answer booklet given. The candidates are advised not to fold the answer booklet in any manner, as it may affect or damage the barcodes permanently. You are prohibited from writing on or tampering barcodes, as they may affect marks allotted to you. Candidates will be disqualified from examination for following: writing their roll number, registration number, name, etc. in any part of the answer booklet, addressing the examiner in any manner whatsoever in the answer booklet, putting any distinguishing mark, religious or any other symbol anywhere in the answer booklet, bringing cell phones, so and so devices. No additional answer books or sheets shall be issued. Answer to any question must be done at one place. Answer should be written on both sides of the paper, starting from page number 2. Do not write in the margin. Candidates are not allowed to leave the examination hall during the first hour from the commencement of the examination. Candidates are not permitted to talk with each other in the examination hall. No one should try to give help to others or try to seek any help from others inside or outside the examination hall. Candidates are not allowed to write anything on the question paper. Infringement by a candidate of any of the instructions printed above will render him.
All right,
My lord.
keep it in mind. Let us come to the question.
Question, my lord. Your lordship may see the
Annexure 5 question.
5A, my lord, the tabulation format, your lordship, the last one,
No, we'll go to the
page 60, my lord, page,
question number 5 to question. The question law property of question paper.
my lord,
That is annexure 5.
my lord, as per the instruction, my lord, the total marks granted for 5A and 5B is total is 4 marks, my lord.
No, it's not.
My lord,
That you are saying, sir.
my lord,
Please come to that. Annexure 5, page 22.
page, my lord, page 22,
Now read at the top. The total mark, full mark is 150.
150, my lord.
Then
Questions are
the
of
questions are of equal value.
equal value.
Answer 6 questions, selecting 2 from each section.
2 questions from each section,
Right.
my lord.
So that means each section carries how much mark? 25 marks.
25.
Achha.
1, 2,
Question
3, 4, 5, 6.
So from section B, the candidate has answered which questions?
5.
Only 5.
5A and B.
No. That means only one question he has attended. He has not attended 2 questions.
2 questions I have
Ah,
attended.
the answer
Wait.
But
He
the question
answered
is-
6 questions, selecting 2 questions
from each section.
each section.
2 questions.
তার মানে ପ୍ରତ୍ୟେକ ସେକ୍ସନ ର ତା ମାନେ ମୂଲ୍ୟ କେତେ ହେଲା 25 ମାର୍କ ତ
25 yes. 12 each question is having 12
ନାଇଁ ପ୍ରତ୍ୟେକ ସେକ୍ସନ ର ପାଇଁ ମୂଲ୍ୟ କେତେ ରହିଲା 25
25.
ହଁ
50
ନାଇଁ।
ତିନିଟା ସେକ୍ସନ
50
ହଁ 50 ରୁ ତିନିଟା ABC ତିନିଟା ହେଲା A under 2ଟା B under 2ଟା C under 2ଟା question.
just 2 questions from each section. Okay, ତା ମାନେ each section ରେ let us say section A ରେ total question କେତେଟା ଅଛି
4ଟା.
Chapter
So
2ଟା କରିବେ.
he will be
ଚାରିଟା
appearing
ତାକୁ
2
ଦିଟା
questions.
we are
2
not
questions.
concerned with that.
Yes.
ଆଚ୍ଛା ତା ମାନେ ପ୍ରତ୍ୟେକ ସେକ୍ସନ ର ମୂଲ୍ୟ ତା ମାନେ ହେଇଗଲା କେତେ 50 ମାର୍କ ତ
50.
ଓକେ
ହଁ.
each section 50 marks ହେଲା
25.
ଆଚ୍ଛା ସେଇଟା ପୁଣି ଡିଭାଇଡ ହବ ତା ମାନେ ପ୍ରତ୍ୟେକ କ୍ୱେଶ୍ଚିନ୍ ହଉଛି କ୍ୟାରିଜ ହଉଛି 25 ମାର୍କ
25 marks.
ରାଇଟ ଆଚ୍ଛା ତେଣୁ ଏଇ ହିସାବରେ ଗଲେ ଆମେ ଯଦି ପଳେଇ ଆସିବା ସେକ୍ସନ ବି କୁ ସେକ୍ସନ ବି ରେ ଟୋଟାଲ କ୍ୱେଶ୍ଚିନ୍ ହଉଛି 5
5,
6
6,
7 8 ଚାରିଟା କ୍ୱେଶ୍ଚିନ୍ ରୁ ତାକୁ ଦିଟାକୁ ଆନ୍ସର ଦେବାକୁ ପଡିବ ରାଇଟ ତାମାନେ क्वेश्चन नंबर 5 ର ମୂଲ୍ୟ ହଉଛି 12.5
A ର 12 half and B ର
नो
yes ma'am
25
ହଁ
ହଁ
ମାନେ
20 अच्छा ठीक
25
अच्छा 5 ର ମାର୍କ ହେଲା 25 ମାର୍କ
25
But that you cannot ascertain. Unless the scheme of marking is seen, you cannot say. Scheme of marking is normally to be done by the chief examiner. And the manner of marking, keeping in view the gravity of the answer, is given.
each question equal
questions are of equal
answer
Equal value ମାନେ 25 ହେଇଗଲା
25
କିନ୍ତୁ A B ରେ ଆମେ 12.5 କହିପାରିବାନି unless the scheme of marking is seen.
That we have also mentioned, madam. There is no specific scheme of evaluation.
No.
of our High
We have
Court pillar
mentioned para
to
6 of
resolve
the
this issue.
para
There
6,
is no
madam.
scheme.
That is in my case and that
Alright,
is
Page 2, para 6. It is para 6, my lord, of the counter affidavit. It is relevant to submit that there is no such specific scheme of evaluation available with the commission.
it's a mechanical error.
Generally, eminent professors, readers are appointed as chief examiner or examiner for evaluation. Chief examiner discusses about the question and answers with the examiners and verbally intimates the evaluators regarding scheme of evaluation for bringing uniformity in evaluation and for reducing subjectivity. And my lord, para 8, my lord, towards the last, The chief examiners with the rank of district judge who are appointed with due approval of the Honorable High Court to validate the answer scripts evaluated by the examiners, and if necessary, they were empowered to re-evaluate the same. Hence, question of improper evaluation by the examiner does not arise. And there is a notification of 2017 also I've annexed that.
Just a moment.
Wait. No. Let us be clear on this. So if since now it is very clear that there are total 3 sections. तीनटा section ना नहीं? Section A, section B and section C. तेणु obviously
Each section carries 50
each section रू से दुईटी question को answer देई परियो. तेणु तामाने each section ना value हैला 50 marks, let us say. 50 marks रे तामाने प्रत्येक section रो प्रत्येक question it जदि लिखा है equal value माने mark होची 25 mark
25
प्रत्येक question नो.
गोटे क्वेश्चन
तेणु 5 number रो से ए जो section B रो केतेटा question से answer देई.
सेक्शन बी दीटा
कोटा 5 and
8
5 and 8. So 5 8 ପାଇଁ ସେ କେତେ answer ପାଇଛି? Answer script ରେ 8 ପାଇଁ ପାଇଛି ସେ 9 mark. दे से answer sheet ଟା देखियो. Answer sheet ଟା काई?
Man answer the page 29.
1029. हाँ से पढ़े से कितने पेज रो अछि सेटा?
54 ରୁ start answer.
କେତେ ପାଇଛି question number 8 ରେ? 9 ପାଇଛି.
ଟିକେ ଆସିଲା देखिए.
नहीं 5 plus 4 9 पाइछि. 5 plus 4.
हाँ, that is nice.
Please come to that.
Total is written.
को पेज रो अछि से answer टा?
57 57
50, let us see.
56 57
Okay. 56 57. Ma'am.
56 54
It starts from
54 54
We are about this other question in that particular
54.
section.
54
So he has answered the question number 8 first at page 54.
54
Just come.
5 marks.
अच्छा से section B रो ठीक है क्लियर है जीवा. Section B रो तामने से दीटे question answer देइची. गोटे होची question number 5 आ गोटे होची question number 8. Right? प्रथमे question number 8 को answer देइछन. ना नहीं. अच्छा. Question number 8 page 54 answer देइची तापरे आ गोटे से ये केतेटा ये अछि
ए बी दीटा अछि.
A B.
ए बी. अच्छा ए और बी. ए आरंभ हैला 54 रे. एटा कंटिन्यू कला को पर्यंत
57 57 7
ना
एटा केते पर्यंत
8 हला 55
50 हां 54 ରୁ 55 वाला.
सेते 5 मार्क दिया.
अच्छा देखो तो 5 मार्क दिया हला ता पई.
54 ରୁ 55.
हां
54 ରୁ 55 ରେ ତାକୁ ଦିଆଗଲା 5 ମାର୍କ
5
କହୁଛନ୍ତି.
मार्क
ହଁ ତାହେଲେ
ए दिया हला 5 ए रे.
हां
ए पई दिया हला 5 मार्क.
ए पे 5 तापर बी स्टार्ट्स
8 ए रो
ଏଇଟା
बैक आरंभ.
କିନ୍ତୁ ଏଟା ତ କ୍ୱେଶ୍ଚନ ନୁହେଁ, ଏଟା ତ 4 କ୍ଲାସ 4 ହେଇଛି.
ସେଟା ସବସେକ୍ଟ योर आंसर देउ. एटा
8A
8 ए रो एटा सब तार इलस्ट्रेशन
1 2 3
नहीं.
4
तार ए जो ये दो एनालिसिस करी
କରିକିରି ଏଟା ଫାଇନାଲି ମାର୍କ ଦିଆଗଲା 5 ରାଇଟ୍.
एटा होता आंसर.
ଗୋଟେ ଆନ୍ସର ଗଲା 8 ରେ ପୁରା ଗଲା.
तापर देई
ତାପରେ B
तो 8B ପାଇଁ ସେମିତି आंसर स्टार्ट हैला पेज 55 ରୁ सरीची को पेज रे
57
7
57
7 रो टॉप रे तो 4 मार्क दिया
रोन तो ठीक है रोन.
बी पे
57 ने 4 रे दियाला
टॉप रे देला
4 मार्क.
4 एंड
5
टुगेदर
plus 4 कले 9 पर
9 पर हैला.
टुगेदर 5 plus 4
5 plus 4 हैला 9
Nine.
हैला. तापरे आसिला हमरो नेक्स्ट क्वेश्चन देइची 5 नंबर.
सेटा से कला कोटा सेक्शन
आरंभ
क्वेश्चन 9.
हां एटा होची क्वेश्चन 8
हां एटा तापर 9 से कला.
नहीं 9
एटा कोटा 5A 5A
5
5A
5
सेक्शन लेकिन ना
5 एर आरंभ हैला 57 रो.
57
दीटा क्वेश्चन से दबाक पड़ियो आंसर. 5 ଆଉ 8 ସେ ଦେଇଛି
ହୁଁ।
8 ପାଇଁ ସେ ପାଇଗଲା 9 ମାର୍କ
Right.
ବର୍ତ୍ତମାନ 5 ପାଇଁ ପାଉଛି 5 ର ଆରମ୍ଭ ହେଇଛି ପେଜ 57
ହୁଁ।
ସେଟା ସରିଛି କେତେରେ
58
58
ଏଇଟା ହଉଛି 50
ହଁ ଠିକ ଅଛି
ଆଉ
58 ରେ
ଆଉ
ମାର୍କ
B-
ମାର୍କ କିଛି ଦିଆହେଇନି
ନା ଆଉ ବି ଆରମ୍ଭ ହେଇଛି
ତାପରେ B ଆରମ୍ଭ ହେଇଛି
ଆଉ ଟୋଟାଲ ମାର୍କ ହେଲା 4
B ମାର୍କ ହେଇଛି ଆରମ୍ଭ ହେଇଛି 58 ରୁ ସରିଛି କେତେରେ
60
ଓହୋ
60
ଆଚ୍ଛା ଆଚ୍ଛା
60 ରେ ତାପରେ ଲେଖା ହେଇଛି 4
ହୁଁ
yes now Mr. Mahanti you see the if you say that you have answered for 5A just see previously what has been done in question number 8 ସେଇ ସେକ୍ସନ ର ଆପଣଙ୍କୁ ସେ ଦିଟା ଆନ୍ସର ଦେଲା ଗୋଟେ ହଉଛି 5 ଆଉ 8
My lord, that
8 ଟା ଆରମ୍ଭ ହେଇଛି ପେଜ 54 ରୁ ହେଲା 8 ର 8A ସେଠି ଲେଖା ହେଇଛି
my lord,
ଦେଖିଲେ ସେ କ୍ୱେଶ୍ଚିନ୍ ଟା ଷ୍ଟାର୍ଟ ହେଇଛି ଆନ୍ସର ଷ୍ଟାର୍ଟ ହେଇଛି ପେଜ
50,
54 ରୁ
54.
ଏବଂ ସରିଛି କୋଉଠି ନା 55 ରେ
My
55 ରେ ସରିଲା ଏ ସାଇଡ ରେ ମାର୍କ ଦିଆଲା 05 ଦେଖିଲେ ନା ତାପରେ ଦେଖିଲେ ନା ନାଇଁ
my lord.
ତାପରେ B ର ଆନ୍ସର ଆରମ୍ଭ ହେଲା
D, then it has been evaluated.
ହଁ B ର ମଧ୍ୟ ସେପାରେଟଲି ଇଭାଲୁଏଟ ହେଲା
57,
ଏବଂ
my lord.
ସରିଛି 57 ରେ 57 ରେ ସରିଲା ପରେ ତାର ସେ ମାର୍କ ପାଇଁ ପାଇଛି 4
ମାନେ?
ଶେଷକୁ ମିଶା ହେଲା 5 ପ୍ଲସ 4 ହଉଛି 9 ଯୋଉଟା କି ଟପ ରେ ରିଫ୍ଲେକ୍ଟ ହେଇଛି
My
ଠିକ ଅଛି ତାପରେ ତା ଦେହରେ ଆଉ ଗୋଟିଏ ମାତ୍ର କ୍ୱେଶ୍ଚିନ୍ ସେ ପରମିସିବୁଲ ଏବଂ ସେଟା ସେ ଆନ୍ସର ଦେଲେ କ୍ୱେଶ୍ଚିନ୍ ନମ୍ବର 5 ର ମଧ୍ୟ
my lord.
5A ଆନ୍ସର ଦେଖା ହେଲା ଟିକ 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 ସବୁ ଦେଖିଛନ୍ତି ସେ ମଧ୍ୟ ମାରିଛନ୍ତି ଏକ୍ସାମିନର ହେଲା ସେଇଟା ଚାଲିଲା 57 ରୁ 58 ପର୍ଯ୍ୟନ୍ତ ହେଲା
My lord.
58 ରେ ସରିଲା ଏ ପାଇଁ ସାଇଡ ରେ କିଛି ମାର୍କିଂ ନାହିଁ ଯେମିତି ଆରଟାରେ ହେଇଥିଲା ଏଥିରେ କିଛି ନାହିଁ B ର ଆନ୍ସର ଷ୍ଟାର୍ଟ ହେଲା ପେଜ 58 ରୁ ଇମୁଭେବଲ ହେଡିଂ ଲେଖା ହେଇଛି
My lord.
ହେଲା ସେଠୁ 5B ଚାଲିଲା ଏବଂ ସେଟା ସରିଛି କୋଉଠି ନା ପେଜ 60 ରେ ଏବଂ ମାର୍କିଂ ଦିଆଯାଇଛି 4 ହେଲା
My lord.
ଯଦି 8 ପାଇଁ ଏଇ ପ୍ରୋସିଡିଓର ଟା ଆଡପ୍ଟ ହେଲା ଯେ 5 ପ୍ଲସ 4 9 ୟା ପାଇଁ ଯଦି ଦିଟା ଯାକ ପାଇଁ ଆନ୍ସର ଦିଆ ହେଇଥାନ୍ତା ତାହେଲେ ସେମିତି ମଧ୍ୟ ଏତିକି ପ୍ଲସ ଏତିକି ଆପଣ କହୁନାହାନ୍ତି ଯେ 5A ପାଇଁ ସିଏ 0 ମାର୍କ ରଖିଛି
My lord.
right so that is his grievance that 5A has not at all been marked
My lord, one thing, after all this evaluation done, well, it has been totally, it has been calculated on the answer scripts.
totally absurd
My lord.
ଟୋଟାଲି ଆପଣ ଏଇ ଯୋଉ ମାର୍କ ଲାଷ୍ଟ କୁ ଦେଇଛନ୍ତି ତାକୁ କ୍ୟାରି ଆଉଟ କରିଛନ୍ତି
My lord, that
ଆପଣ ଯଦି ମାର୍କ ଦେଇନାହାନ୍ତି ନା ତେଣୁ ଆପଣ ଯୋଉଟା କ୍ୟାରି ଆଉଟ କରିଛନ୍ତି ଫ୍ରଣ୍ଟ ପେଜ ରେ ଏଇଟା ବେସିଂ ଅନ୍ ଏଇ ଯୋଉ ଲାଷ୍ଟ ଭ୍ୟାଲ୍ୟୁଟା
my lord,
ଆପଣ
that
ଦେଇ ଦେଇଛନ୍ତି ମନେକର 8 ନମ୍ବର ପାଇଁ 9 ସେଠି ଉଠେଇ ଦେଇଛନ୍ତି 5 ନମ୍ବର ପାଇଁ ହଉଛି 4 ସେଠି ଉଠେଇ ଦେଇଛନ୍ତି କିନ୍ତୁ 5 ର ଯୋଉ ଦିଟା ପାର୍ଟ ରହିଲା 5A
That is-
ଆଉ 5B ସେଥିପାଇଁ ଯଦି ଇଣ୍ଡିଭିଜୁଆଲି ମାର୍କ ହେଇଥାନ୍ତା ଆପଣ ଯୋଉଠି 4 ଲେଖିଥାନ୍ତେ ଆପଣ ଯଦି ଲେଖିଥାନ୍ତେ 00 ପ୍ଲସ 04
that
matter ends there କି 2 ପ୍ଲସ 2 4 matter ends there ଯେ
Matter.
ଏଠି କିଛି ଲେଖା ହେଇନି so that is his grievance
the
ଆଉ
examiner
ଏବଂ
was-
ଆପଣ କରିନାହାନ୍ତି ଯେ ଏଟା ଛକି ଅର୍ଥାତ 5 ଏଟା ଭୁଲ ଆନ୍ସର ଏଟା ଛକି ସେମିତି କରିନାହାନ୍ତି ତେଣୁ ଏଠି କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ତାର ସେ ଗୋଟେ ପ୍ରାଇମା ଫାସାଇ ମେକଆଉଟ କରୁଛନ୍ତି କେସ୍ ଏଠି ଆମର ଏଇ ଯେ କ୍ୱେଶ୍ଚିନ୍ ଅଫ ରିଭ୍ୟାଲୁଏସନ ଇନ ଦି ସେନ୍ସ that one question has not at all been one answer has not at all been
Well-
marked that is the difference between what has been pronounced in those judgments that revaluation
that
is
is right.
not permissible but if a candidate has answered a particular question but that has
and
not been
valuation is
marked,
not written.
that valuation is not there so that would be an exceptional case
But that also, my lord, depends upon the
The other
subjectivity of
way round,
examiner.
the other way round,
Examiner.
the other way round,
Well-
the pattern of marking followed in 5 question number 5
Five.
is not the pattern of marking in any other question.
Rest,
If you can say that no, that is also the pattern of marking being followed in any other question,
well,
probably we would agree that yes, it has been marked.
ଆପଣ
But that is not the pattern.
କୌଣସିଟାର ଆନ୍ସର ଦେଖାନ୍ତୁ
My lord,
जोटारे सेमती एमती लास्ट को दीटा जगह ପାଇଁ ଗୋଟେ ମାର୍କ ଦିଏ
similarly,
ତ ଆମେ ସେଇଥି ପାଇଁ ଗୋଟେ ଡିଟେଲ ଅର୍ଡର ପାସ୍ ହେଇଥିଲା ତା ଦେହରେ ଯେ ସବୁ କ୍ଷେତ୍ରରେ ପ୍ରତ୍ୟେକ କ୍ୱେଶ୍ଚିନ୍ ପାଇଁ କେତେ କେତେ ମାର୍କ ତାକୁ ଲାଷ୍ଟ କୁ ପ୍ଲସ୍ କରାଯାଏ and that should be the right procedure
well,
ଏ କ୍ୱେଶ୍ଚିନ୍ ପାଇଁ ସେ ଏତିକି ମାର୍କ ରଖିଲା ଆନ୍ସର ପାଇଁ A1 C2 ନା ମନେକର ଗୋଟାକର ତିନିଟା ଆନ୍ସର ଅଛି ଗୋଟେ ସେକ୍ସନ ର ଗୋଟେ କ୍ୱେଶ୍ଚିନ୍ ର ତିନିଟା ପାର୍ଟ ତେଣୁ ଇଚ୍ ଭ୍ୟାଲ୍ୟୁ ହଉଛି ସମାନ 4 4 4 ଯଦି ଆପଣଙ୍କର ସେମିତି କିଛି ନାହିଁ ତେଣୁ 1 ନମ୍ବର ପାଇଁ ଏତିକି ପାଇଲା 2 ନମ୍ବର ପାଇଁ ଏତିକି ପାଇଲା 3 ନମ୍ବର ପାଇଁ ତାକୁ ମିଶେଇ ଦେଲେ 4 ଫାଇନାଲ କୁ ଚାଲିଗଲା ସେଟା ସବୁଥିରେ ହେଇଛି ଏଇ ଗୋଟିଏ ମାତ୍ର ଜାଗା ଯୋଉଠି
Evaluation ହେଇନି.
evaluation
There is no evaluation at all. So the question of evaluation is not there when the candidate has answered a question. It is not question of rechecking. It is not a question of re-evaluation. It is a question of not valued at all.
an answer which has been given and you have put a tick mark
my
On
lord,
this
that,
point, our High Court has given a judgment. Well, I'm just passing. This is on this point, and this is covered. And my lot of friend also was there in that case also. He's a party to this. Similar circumstances, and same exact similar ditto counter affidavit they have also filed, which they have filed here. The same thing was filed. Mechanical approach. ଏଥିରେ ହେଲା ମାନେ ଭାଲ୍ୟୁଏସନ କରାଗଲା ଆଉ ମତେ 2 ବର୍ଷର ସିନିୟରିଟିରେ ମୁଁ ଆପଏଣ୍ଟମେଣ୍ଟ ପାଇଲି
no that is a different first of the valuation
ମାନେ that is there that has been dealt with
but copy may provide.
ପ୍ରଜ୍ଞା ଲଳିତ ବିଷୟ
It is not so important. It is also it is all a total equation. There has not been proper marking of the answer script relating to question number 12b, law of proposition, law of proposition. That's the intuitive scheme of valuation. Intuitive scheme of valuation जोटा हमर अछि equal prepared by the chief executive scheme of valuation. It in absence of scheme of valuation, will go by the direction.
so Mr. Mohanty
Well,
we are passing an order today that you are to send this particular question number
Answer script.
5 both the parts section B ro question number 5A and 5B
With
along with the
script.
answer sheet which has been given for that. Sealed cover, National Law University Vice Chairman, MS Law College University Vice Chairman and University Law College. Sealed cover is separate पठेबे. Vice Chairman काहाको entrust करेबे. If property
Vice
is
Chancellor.
Vice Chancellor.
Vice Chancellor.
He has to give it in the marking in to you in sealed cover. Dita jako tinta jako asila pare will see what is the thing.
Sealed cover.
Sealed cover.
my lord only one question as per that judgment before this my lord the scheme of evaluation has to be
No, we are not concerned because they are not asking for that. If they will not say that there is a scheme of marking, why should we? There they have filed a scheme of marking. Here they say that it bears equal mark. So why should you go by that?
That means
We are not concerned. with
question number 5 carries 25 marks.
that. And on oath they have said that no such scheme of
Right.
evaluation is there.
Question number
Who
5.
are you to say?
Question
Only
number,
they can say.
Question number 5 carries 25 marks. Now it is to be assessed by the respective and the
As a lordship may direct. Only thing, my lord, the recruitment was of the last year. It
that
has
we'll
been
see.
That part
completed.
again, let it come, then we'll see.
Now we'll see what
Your lordship may take.
take down. The petitioner, Jyotirmay Datta, has filed this writ petition with a prayer, inter alia with a prayer for a direction to the OPSC to cause the evaluation of the left out answer scripts in law of property in question number 5 bracket A as per guidelines provided under the scheme of evaluation. By a detailed order on 27/11/2024, we took into account the contention raised by the London Council for the petitioner, Mr. Srinivas Mahanti, that it is not a case of revaluation of an answer to the question which has already been valued. Rather, it is a case where petitioner has answered a particular question rightly and she has not been given any mark for such answer. Acha. According to
Right.
which according to the Mr. Mahanti drew the attention of this court on that day to the question paper on law of property, which is having full mark of 150. And it is mentioned that the questions are of equal value and the candidate has to answer 6 questions, selecting 2 questions from each section. Thus, since there are 3 sections, that is section A, section B, and section C, the petitioner, so far as section B is concerned, has given answer to question number 5 and 8. So far as answer to question number 8 is concerned, she has attempted first and answer to question 8 bracket small a starts at page 54 and ends at page 55, and the mark has been awarded for that answer is 0.5. Similarly, he has answered to question 8b from page 55 to page 57, and the mark awarded for this answer is 4, and in the end 0.4, and in the end the marks awarded for 8A and 8B, that is 0.5 and 0.4, has been added to make it 0.9, which has been reflected in the front page of
Mark sheet.
which has been mentioned in the mark sheet
Annexure.
annexure 6. Okay. So perhaps answer to question number 5 is concerned, which is divided as which is 5 divided in 5A and 5B, comma, the answer to 5A starts from page 57 to 58, and it seems that there is no marks given for that answer, as has been mentioned in answer to 8A and 8B. And so far as answer to 5B is concerned, it starts from page 58 and ends at page 60. And in the end, the mark has been awarded as 04. And accordingly, the same has been mentioned in the mark sheet under annexure 6. We noted down the contention of Mr. Srinivas Mahanti on that day in the order dated so and so, that since the petitioner has answered parts of the questions, that is 5A and 5B of question number 5, but for question number 5A, but for answer to question number 5A, no individual mark has been awarded. We asked Mr. Mahanti, Learned Counsel for the OPL, Senior Advocate, to obtain instruction as to whether the contention of the Learned Counsel for the petitioner, that the petitioner has not been given any mark for question number 5A, is correct or not. And if she has answered both the question correctly, then how for each individual answer mark has not been added in the end, as has been done in respect of other answers
in the answer script.
in the answer sheet. Today, Mr. Mahanti has filed a counter affidavit on behalf of the opposite party number 2, OPSC, wherein in paragraph number 7, it is mentioned as follows. Quote entire paragraph. After going through the counter affidavit and hearing the Learned Counsel for the respective parties and going through the question paper on law of property, comma, by annexure 5, the answer sheet of the answer script of the petitioner by annexure 6, we are of the view that we propose the following. Opposite party number 2 shall send. Question number 5 of law of property. Like entire question.
Question paper and answers.
Question paper and answer sheet of the petitioner to the vice chairman,
Vice Chancellor.
vice chancellor of
Three universities.
3 university, that is
NLU.
National Law University Cuttack, comma
MS University. MS.
Madhusudan Law University Cuttack, and Capital
Right, University of Law.
University of Law, Bhubaneswar, so that the vice chancellor himself or through
The concerned
uh,
professor.
concerned professor
of the concerned
of
subject.
the
subject.
on the subject shall assess the mark on question number 5A and 5B separately, and send it in the seal cover to the opposite party number 2, who in turn shall produce it on the next day, which is fixed to so let it come in January.
January was also. January.
December ଦେଇଦେବା ତ ପୁଷ୍କର କାହିଁ ଦରକାର? ସେଇଟା last time. It is 15 to second week so 10th to 10th January.
January around 13 तारीख तेरा supplementary मिलेगा 15 तारीख.
Right.
Is this matter on 15th January 2025. A free copy of the order be handed over to the land council for the opposite party number 2. এটা খালি তো লিখে দেবে land council for the petitioner based reliance in the case of
scheme of evaluation से नहीं करना है.
yeah Lalit
ନା କରୁଛନ୍ତି ନା
Minister of Justice
scheme of evaluation तो ଥିବ ନିଶ୍ଚୟ ନା.
PSC.
ଆମେ କହିଲେ ହବନି ନା ଥିବ କହିଲେ ହବ
ନାଇଁ ସେମାନେ କହିନାହାନ୍ତି କିଛି. To that
ନାଇଁ,
they
ନାଇଁ.
have no answer.
if it is not before this court then the court will go for the normal जे 50% 50 mark in each section we'll go by that. Why should we?
এটা top রে লেখা
We don't know whether it will be in your advantage or in your disadvantage. Suppose section B will have more mark than the B, so don't go by that.
That is it.
Yes.
Item number 2.
Lordship of last order dated my lord 13/11/24. Order dated 13/11/24.
Last again, the Lordship directed to take instruction regarding the
1311 order.
representation of the petitioner matter. So far as the instruction,
Yes.
and they have supplied that instruction, I may place that matter.
ଆପଣ ଏଇଟା କଣ ମାନେ ପ୍ରାଇଭେଟ ଜିନିଷ ନା କଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଯାହା ଦଉନାହାନ୍ତି ତାଙ୍କୁ ଗୋଟେ କପି ଦିଅନ୍ତୁ ଇଏ ଦିଅନ୍ତୁ
Internal communication. If your Lordship say, I will file a counter affidavit. They said that the above land is a joint property stand
କୋଉ ପାରାଟା
but first para.
ଆପଣଙ୍କୁ ଏତିକି କେବଳ କୁହା ହେଇଥିଲା ସେ କହୁଛନ୍ତି
That is pending matter.
Ah,
That is pending due to
that is what
disputed
that's all.
due to disputed fact that cannot.
Made
Yes.
we are not
That is pending.
সেটা LA court নিজে করিবেনি if there is a disputed question of title
Yes, yes,
whether the LA court can interfere in it that they will decide but
Yes.
the matter is pending for reference why
Yes.
So where have you stated that it is pending still? Page number?
Uh,
In the undersigned declare.
In view of the above, the undersigned found the claim of the petitioner is with ill intention and is disputed nature. The case file is under verification as per law established.
you have given
Last part.
last it তো pending ଅଛି ସେ କହୁଛନ୍ତି ମୋ
pending
matter ଟା pending ଅଛି for more than 10 months
That is
let
pending.
it be disposed of
Yes, sir.
annexure 5
দেখুন this writ petition has been filed by petitioner Leeladri Singh alias Neelandri Singh with a prayer for a direction to the opposite party number 2, the deputy chief engineer (CON dot CALA Special Railway Project SE Railway Jharsuguda) to refer the case of the petitioner in respect of so and so MS Khata number so and so comprising of so and so to the civil court for proper apportionment of the case. Land Council for the petitioner submitted that the petitioner under section 20H4 of the Railways Amendment Act 2008 for referring the matter to the civil court for its adjudication is sub judice. And even though more than 10 months have already passed, the petitioner has got no response from the opposite party number 2 as to whether his case has been referred to competent civil court for adjudication or not. Admittedly, you have not yet referred the Land Council for the
Railway.
has not yet been disposed of whether you will
No,
refer or not that
pending.
is up to you
Pending.
Mr. P.K. Padil and Deputy Solicitor General of India, along with Mr. D. Goshat and Central Government Council,
BS
BS
Right.
was given time to obtain instruction in the matter. And today, the instruction has been produced, and Mr. Raigur submits that the matter is still pending with pending opposite party number
Deputy
2.
Chief Engineer Construction.
That is opposite party number 2.
2.
Opposite party number 2. In view of such submission, we dispose of the writ petition, the direction to the opposite party number 2 to take a decision on number annexure is annexure 5 within a period of 3 months from the date of production of the certified copy of the order, and communicate the order to the petitioner within 15 days of the taking the decision. It is made clear that we have not expressed any opinion on this one, so it is taken on.
Only I pray, Lordship, till disposal of the referendum, not to disburse that amount, my lord, 10%.
I don't know whether now you have seen the what is
During the adjudication, how they dispose the amount. The question of disposal not arise. If there is no finality, they cannot dispose the amount.
Then that may recorded.
Mr. Padi, we would say that why this type of petitions are filed here? Why are you not taking a decision 10 months, 2 years, just whatever, just intimate this much is to be said, whether matter is to be referred to the civil court or not, whether he has, you are pending, they are coming here.
Might have lack of knowledge, my lord. I think so. I have no instruction. There is a lack of knowledge. Yes.
All right, next.
Yes.
Item 3.
Order of the tribunal acting acid in this writ application.
Mr. Trilochan Roth, you copy the
Yes, sir.
Yes. Which order you are challenging?
order dated
34th, 2024.
Annexure 1.
Annexure 1. Yes.
Only the short question is before final consideration.
Hmm.
Whether an employee who is retired from the service can get the promotion in respectively effect.
Promotion?
Retrospectively.
Retrospective effect. Though his case has been considered by the DPC after his retirement.
Hmm.
He is retired on September 2020. The DPC held on 23/11/2020.
23/11.
2020. After his retirement, DCP held, madam. And his case also, along with others, considered and tribunal held, the national commission can be given provided to the petitioner. Though regular permission is not be granted. That has been accepted before the worship. The worship may kindly see.
You just come to the page 21, that is the input order, and come to the very first page where the prayer has been quoted. What was his prayer before the Land and Central Administrative Tribunal?
May the permit to place.
Huh.
The applicant challenging the order of rejection by the respondent whereby he has been denied promotional benefit, has filed this way praying the following reliefs. To quash the email reply under Annexure A by 13, Annexure A by 17, and Annexure A by 14, and directed the respondent to grant promotion to the applicant to the level of STS Group A from 1/1/2020 till the date of his superannuation and release to him the differential salary of the period of 1/1/2020 till 39/2020, and the additional pension and retirement dues to which he would be entitled upon a refixation of pay on the date of superannuation with a reasonable period. That
Okay.
is his prayer.
All right. Now you come to the operative part of the order.
Madam. Lakshmi,
That is come to paragraph number 9.
madam.
Relevant page number, running page is 24.
Yes, madam.
Yes.
It is clear from the procedure prescribed in the above MO that while returning officer would not right of actual promotion, but that does not prohibit grant of notional promotion to them. The respondent have granted promotion to others from 1/1/2020. That is on the date when the applicant was in service. Just the fact that he has retired on 39/2020 and DPC was held on 23/11/2020 should not deprive him of his right of promotion. But since he had not actually working in the promotional post, the applicant needs to be notional promotion so that he can benefited of fixation of pension and retirement dues. Extending notional benefit is not like to have any adverse consequence for others in terms of the service, monetary and pensionary benefits. Similar view has been taken in principal bench. In way number 1519 of 2018. In view of the above discussion on the wage allowed, to the extent that the applicant is extended the notional promotion from 1/1/2020, the date when the other get the promotion for the vacancy of 2020, the applicant will be entitled to consular benefit like fixation of pay, annual increment, if any due, enhanced pensional benefits. Respondent are directed to pass appropriate orders in terms of the above direction.
Okay. Now that very relevant OM that is dated 10/4/89 has been relied upon you. That has been quoted in that page number 24.
Yes, sir.
Just read where there is prohibition that this financial benefit cannot be granted.
You also may, and we see that has been in the counter manner prior to this notification of MO. Another MO is the annexure. You also may can see page 143. That is
Your counter affidavit before the CAT.
Yes,
120.
123. 143.
43.
That is the part of annexure R by 3 for our counter. You also may kindly see at 6 point in middle 6.6
6.4.4.
6.4.4.
While promotion will be made in the order of the consolidated select list, such promotion will have only prospective effect even in cases where the vacancy related to earlier years.
No, we are not on that. We are only that. You see, holding of DPC in a regular interval, it is there or not?
Yes,
That-
madam. Yes, madam.
So suppose you delayed this DPC and for which he retired. So if you would have held the DPC at right time, that is in month of January, his case would have been considered.
Yes, madam.
So, and he would have got the benefit. So what fault lies with him? Merely because you delayed the DPC.
Madam, the reason being we have mentioned in that our counter affidavit as well as the stand we have taken that there is a two provision, one promotional post and a direct recruitment. For BPC, all the 6 years and records of all that has been take place after some time. That is the reason the delay has been occurred of the BPC.
No, ସିଏ ତ ଆଉ ସେଇ ପୋଷ୍ଟ କୁ ଆଉ ଇଏ କରୁନାହାନ୍ତି, ସେ କହୁଛନ୍ତି ସେଇ ଯୋଉ ପିରିୟଡ ର ମତେ ଫାଇନାନ୍ସିଆଲ ବେନିଫିଟ ଟା ଯାହା ହବ ମତେ ଦିଆଯାଉ, ଯୋଉଟା କି ଆକର୍ଡିଂ ଟୁ ଅର୍ଡର। ତେଣୁ କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ତାଙ୍କର ଫଲ୍ଟ କଣ? ଆପଣ ଡିଲେ କଲେ, ଆପଣ ଡିପିସି କଲେ ନଭେମ୍ବରରେ, ଡିପିସି ଯଦି ଜାନୁଆରୀରେ କରିଥାନ୍ତେ ତାଙ୍କ କେସ୍ କନସିଡର ହେଇଥାନ୍ତା ନା ନାହିଁ? ଏବଂ ସେ ପାଇଥାନ୍ତେ ନା ନାହିଁ? ତାହେଲେ
But my lord, when otherwise circumstances when the DPC has not been made, when the after his retirement, this DPC has been made. That
So what is the ratio decided by the Supreme Court very recently, only 10 days back, denying the notional promotion and substantive promotion after the retirement? Have you gone through it?
That is the reason I want you also make put up after vacation.
You see that? Under what circumstance, whether it fits into the present case or not? Because there is a denial of notional promotion as well as substantive promotion after retirement. Have you seen, Mr.?
Yes, Mr. Otho?
Can I just make one or two lines submission?
Yes.
Page 23 of that order, my lord. They took a plea that process took some time. Tribunal has recorded the reason and rejected it by saying you have not assigned any appropriate reason for the delay. And for the delay, I was not responsible, madam.
No, we are convinced on that. Yeah.
One thing more. The persons who has got my friend is relying upon 1989 circular, my lord, which says that it will be prospective. I had filed in my original application the documents showing from 1989 onwards till this case of promotion of the petition applicant came. In all through, Postal Department has granted even granted retrospective promotion to the retired employees, even to posthumous.
No, my lord has even gone one step ahead of it. My lord has already stated that had it been the case that the DPC would have been taken in time, whether he would have got the promotion or not. He says yes.
Particularly, my lord, the persons who got the promotion, they have got the promotion retrospectively.
Again,
all the persons have got retrospectively.
Mr. Rath, you are not able to understand that.
From 1/1/2020,
we do agree with you. My lord has already agreed with you. The only
supplement.
No need to supplement. The only you supplement if the decision of the Supreme Court speaks other than the one that fits into your fact or not. Because Supreme Court has denied. That is how I am saying. After retirement, this promotional, notional promotion or substantive promotion prior to superannuation has been denied in the decision. Kindly see.
This particular, possibly my lord is speaking of that West Bengal judgment. West Bengal judgment, my lord. Here, that is a case of state government, my lord. There was a bar under the rules. But in this case, my lord, the 98 circulars says, but they use the word very cautiously, that man will not get actual promotion.
Means?
actual promotion.
Means
My lord,
you will get notional promotion.
my lord, just,
Means you will get notional promotion.
yes.
Yes, we
That is
know,
what the
sir.
tribunal has granted.
We know.
My lord, had it been the intention of the government to say that man will not get any promotion, my lord, they would not have used that term actual promotion.
We agreed.
That is what I'm
My
saying.
lord has made it clear. You simply see why the Supreme Court has denied. That's all. Why? Is it the same case, same fact of case,
The
or not?
facts are different. Just examine that.
Examine that.
That is given sufficient hint to you. Just
It
go
may
with
not
that.
be
It may not be that
applicable to your
in
case,
the
but you
factual
kindly see.
scenario it may be different. Just go through the decision. We are issuing notice. It's not that we are not. Just
Will be issuing.
My lord,
this writ petition has been filed by the Union of India challenging the order dated 30/4/2024 passed in OA number 317 of 2021. London Central Administrative Tribunal, Cuttack Bench. Mr. Biswajit Maharana, London Central Government Council, along with Mr. Pahi, Pani ko natak uttar rakhiye, submitted that the opposite party number 1, Sanjay Kumar Mahapatra, filed OA number 317 of 2021 with a prayer, quote the prayer portion from page number 1 and 2. And the London Central Administrative Tribunal, by impugned order dated so and so, after taking into account the DOPT OM dated so and so, the relevant portion of the DOPT OM dated so and so, has been pleased to hold as follows. Quote paragraph number 9 and 10. It is the contention of the Land Council for the petitioner that where are your grounds?
At para 7, man.
Paragraph 7. Referring to the grounds taken in paragraph 7, that the impugned order passed by the so and so is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Mr. Trilochan Roth, Land Council, has already entered appearance for the opposite party number 1, and he has already been served with a copy of the writ petition. No notice is required to be issued to opposite party number 2. Put up this matter on such and such date. Counter affidavit, if any, be filed in the meantime. Yeah.
Item 4.
Item 4. Last occasion, this honorable directed to take instruction. You have not received instruction. I pray for some other day. Order dated 27/11. The Tahsildar is
This man is still there in that Pani tank.
that Tahsildar is not a party. We are unable to. So GA department record stands in the name of GA department. So we have issued a letter, but Watco is issuing notice. Whether the land should have been allotted in the favor of the Watco for construction
No, you
purpose.
take instruction, that's a different matter. But he stated that there was likelihood of his disposition because she was staying there. All these things he had averred, and that is the urgency why you are.
Yes, madam. That is the 23 notice was issued. 2023. So I have to take instruction whether the man, if he is he will be within the beneficiary list of Awas Yojana.
That is there.
Then it will be provided, but not the once the land is allotted in favor of some construction other purpose, it is he cannot claim right over that property.
No, if he was in the list of beneficiary, what are you doing for those beneficiaries? Whether there is anything to provide for the semane ବହୁତ ଦିନ ହେଲାଣି ସେଠି ରହିଥିଲେ ଆପଣ ଗୋଟେ ସ୍କିମ୍ ପ୍ରୋଭାଇଡ୍ କଲେ ଯେ ଏଇ ଜାଗାରେ ଯୋଉମାନେ ଅଛନ୍ତି ତାଙ୍କୁ ଅମୁକ ଜାଗାରେ ତାଙ୍କୁ
ରିହାବିଲିଟ
କରାଯିବ ତାଙ୍କ ଲିଷ୍ଟ ହେଲା ସେ ଲିଷ୍ଟରେ ତାଙ୍କ ନାଁ ଅଛି ତ କିଛି ପ୍ରୋଭିଜନ ତ ହେଲାନି ରାଦର କଣ ଆସିଥିଲେ ତାଙ୍କ ଘର ଭାଙ୍ଗି ଦବା ପାଇଁ
I will take instruction to that effect also.
2 dates have already passed.
My lord, that I am concerned that
Stay may be granted.
And general administration is already a party. You can.
But yes, that's
the Land Council for the state seeks some further time to obtain instruction regarding the status of the land. Put of this matter. We are taking in the first week of January.
Till that period, my lord.
Nobody is disturbing your position. Otherwise, you would have been thrown out from that case. Now they are aware that the case is sub judice and they are taking time.
Yes.
Item 5.
Representation
Representation before
Section 4.
opposite party number
cover matter, man.
Are you having a copy?
Ma'am.
That will change करेगा तो कर दीजिए कि change होगा नहीं. Okay. What the matter disposed of?
Item 6.
Yes, Mr. Mahanti.
My lord, the petitioner's prayer was allowed twice by the Honorable Court in the two writ petition at annexure 4 and 10. So the only question lies to carve out the percentage of land loss. I am saying it is 45%, but they are saying disadvantages to the rehabilitation policy. So for the proper assessment of the calculation and percentage of land loss, the RPTSC, my file is pending for the RPTSC, annexure 13, the page 59. It may be decided with reference to the two judgment. It was allowed on merit, the writ petition.
It is lying since 2023. It is lying since September 23.
You have not got any response.
No response.
Dispose it of and communicate the order. Annexure 13 is the
13.
13. Listen. So annexure 13 ta dispose of will
judgment I pray my lord.
This and he has submitted like this.
This is the date claim since 30 years back.
3 months from the date of production of the copy and order to be.
My pharmacy judgment that I would refer 4 and 10.
If you have referred to it, they will definitely see.
And if necessary, personal hearing shall be afforded to the petitioner.
And judgment of
ଲେଖିଛନ୍ତି ପରା personal hearing ଦିଆ ହେଲାଣି ଆପଣ ଦେଖି ପାରିବେନି judgment ର ଦିଟା କପି ପୁଣି ଆଉ ଲେଖିବାକୁ ପଡିବ ଆପଣ petition ରେ detail ଲେଖିଛନ୍ତି and it runs from 6 pages and yes next.
Item 7.
Item 7 covered matter.
କୋଉଠି କଣ change ହବ ଲେଖି ଦେଇଛନ୍ତି disposal.
Item 8.
Yes, Mr. Vishwajit Tripathi.
Item number 8, I am from the opposite party.
Yes.
Agricultural loan I have availed and crop insurance I have done corporate insurance for which 45,000 I have taken to the bank.
have applied to adjust the crop insurance there. But bank has not taken any step for which.
No, 13-4 notice has been issued already.
Yes, my
Then your remedy is elsewhere, not here.
the remedy.
And vacation notice has been issued. All these things are there.
One time
And bank has also filed Section 14 application before the collector, district magistrate Puri, to pass necessary order. And
That order has been passed on 19th July.
already
My-
passed.
my-
Heard the learned counsel for the petitioner, learned counsel for the
bank
opposite
has
party.
not taken into my lord. Bank has not taken into consideration my
the
crop
learned
insurance.
counsel for the petitioner. The petitioner has challenged, has filed this writ petition with a prayer for a direction to the opposite party, that is branch manager, DCB Bank Chandrasekharpur branch, to settle the matter for one-time settlement and not to sell the mortgage property of the petitioner till final disposal of the writ petition. However, it appears that after possession notice was issued by the bank, the sale has been confirmed, no? Sale has been confirmed, and bank has filed application under Section 14 of the Surface Act to take possession of the property, and order has also been passed by the collector in that respect. Suppressive decisions would have further alternative remedies available. We are not inclined to transfer it. This liberty is granted to authority. Yes.
Item 9.
Lord, here the only grievance is that I am the auction purchaser. I have already paid the sale amount 55 lakh, Annexure 1, sale certificate issued on 25/10/2024, but they are not, bank is not handing over the physical possession of the property. That is my sole grievance. You will also make that.
National Bank.
Yes. They have not since 25/10/2024 sale certificate issued. I have paid 55 lakh, but
Your power.
Today they have given the instruction to acquire in this case.
All right. Take the names. Submits that he has instruction to appear for the opposite party bank. The writ petition has been filed by the petitioner Ravindra Kumar Sahu for a direction to the opposite party to hand over and delivery of the physical possession of the auction landed properties pertaining to so and so. With a further prayer to the direction to the opposite party to compensate the petitioner. The learned counsel for the petitioner submitted that after the e-auction sale notice was issued under Surface Act and rules in the newspaper in respect of the property, the petitioner participated and he came out a successful bidder, and accordingly he deposited the entire sale price of rupees 55 lakhs and got the sale certificate. on 25/10/2024, but till date, the physical possession of the scheduled property has not been delivered to the petitioner. Land counsel for the bank seeks some time to obtain instruction on the matter, court of this matter. January of the yes. Copy of the petition be served. You have not been served? No. Achha. Let a copy of the writ petition be served on the land counsel for the bank. Yes.
Item 10.
Yes, madam. Here. Item 10. The petitioner is a land housee under the lower Indra irrigation project. Lordship, kindly come to Annexure 2, page 19. On 2080 petitioner's file, it was way back in
That has not been disposed.
7/12/2023.
Similar order was passed earlier.
My lord, no, my lord.
Oh,
Keeping in view that Annexure 1, same notification, same moja, same piece of land. Lordship, come to the relevant page.
No, your prayer is to,
28.
for disposal of
Disposal,
that
yes,
application under 28.
Annexure 2, my
That
lord.
is Annexure 2.
Aye,
My lord. केबे फाइल कीजिएगा?
It was
12/23.
7/12/2023.
7/12/23.
Keeping in view that Annexure 1.
No, it's
20
all right. You have got no notice from the from the
No,
authority.
till yet, not yet.
All right. This writ petition has been filed by the petitioner Indra Tamba with a prayer for a direction to the opposite party number 4, Special Land Acquisition Officer, Lower Indra Irrigation Project, LIIP, at Post Career Base, Nuapada, to take steps for disposal of the application under Section 28A of the Land Acquisition Act, keeping in view the award passed in LAR number 14 of 2022 in the case of Simachal or Nia?
Simanchal Nial, my lord, page 9.
Simanchal Nia.
Yes.
It was a similar matter, no?
Yes, similar matter.
In the case of Simanchal Nia versus Special Land Acquisition Officer in LAR case number so and so as per judgment and order dated 15th September 2023. It is the contention of the Land Council for the petitioner that even though the petition was submitted on 7/12/2023, but the petitioner has got no response from the opposite party number 4, and therefore necessary direction be given. Land Council for the state has no objection. Considering the submission made by the Land Council for the respective party, we direct the opposite party number 4 to consider the application, a petition filed by the petitioner under Section 1 in accordance with law within a period of 3 months from the production of the certified copy, and also communicate the and if necessary personal hearing be recorded.
Item 1 to 4, that sub item 4 are same. In second and third item, that LR case number kali olga habo 70 of 2009. I have to reflect in the petition.
Item number 10 re jetiyo case achi saman order habo he kono case number oda olga habo.
And so for last connected to matter, you also see at page 20, last connected to matter, page 20. My reference was, my lord, last two, that
and 433.
Durg Singh Tamba and another is Bisam Patel. Also page 20. My reference application allowed. The LA was directed to pay the enhanced compensation amount. It was order passed in 16/12/2024. Almost 10 months have passed. The LA is sitting silent over the matter.
Okay. Will be done.
As you lost. Both the two last same. Oblige.
Item 11.
Same, that is also 21. Representation is 4.
Correction जहाँ वो कर देगी
Representation is 3.
Representation is 3.
Item 15 also project application चाहिए.
15 same. अच्छा. The serial number उड़ा लिख दीजिए तो.
Item 12.
Yes, Mr. Guru.
Petitioner prayer is for release of the land acquisition amount, my lord. which was the land of around acre, 1 acre, 95 decimal has been acquired by the state government. But the background of this case is concerned, my lord, the land which was purchased was earlier in 74.
No, your land has been acquired. You have not been paid any compensation amount.
Because reason is that behind the back is that there's some dispute in the land. And dispute in the sense that the land which was purchased from my vendor.
What was the adjudication? Why you are that is not?
My lord, here I am coming after the order of the learned civil judge, civil court, my lord. I have kindly at page Annex 5.
Otherwise, land dispute was going on between the parties, and in the meantime, that dispute already closed, my lord. In the appeal also, the private opposite party lose the case, but the petitioner has not intimated such fact before the land authority.
The collector is the party in that case, ma'am.
So why are you not filing a representation about this development which he is pointing out? Right. The petitioner, Mamata Sanghai, has filed a petition for a direction to the who has to pay you the compensation amount.
That collector Jharsuguda, my lord, land acquisition.
Direction 2 or 3.
3.
Is to opposite party number 3, land acquisition officer Jharsuguda. To release the compensation award amount in favor of the petitioner for such and such land. The land counsel for the petitioner submitted that in respect of the property in question, the petitioner filed civil suit number 32 of 2006 before the Land and Civil Judge Junior Division, Jharsuguda. Civil suit number लिख लो.
Case number 32 of 2006. That was decreed in favor of the
and the by judgment and decree dated 26 October 2017, the suit was decreed against the defendant, and it was declared that the plaintiff is entitled for a declaration of right title over the suit land, and she is also entitled for all notices and compensation for the acquisition of the suit land. So, it is the contention of the land counsel for the petitioner that in spite of
thereafter it was challenged in appeal.
Annexure
Paragraph
Annexure
page 56.
Aberment कथा अच्छा लिख दो. He further submits that challenging the judgment and decree, the defendants preferred RFA number 27 of 2017 before the London District Judge Jharsuguda.
Additional district judge.
And your judgment भी देना है. 56. Okay. And the matter was taken up by the London Additional District Judge Jharsuguda, and the RFA was by judgment and order dated 27/9/2024 The appeal was dismissed uncontested, and the judgment and decree dated so and so passed by the Land Civil Judge Junior Division Jharsuguda in civil suit number so and so was confirmed. It is submitted by the Land Council for the petitioner that in spite of the orders passed in the civil suit, so also the confirming order passed by the Land and Appellate Court, the petitioner is yet to receive the compensation, the award amount from the opposite party number 3. The Land Council for the Land Additional Government Advocate submits that in case the petitioner files a representation before the opposite party number 3, giving all the details, there would be no difficulty on the part of the opposite party number 3 to disperse the
to consider
award,
and
disperse the award amount in favor of the petitioner within a time stipulated. In view of the submission made by the Land Council for the respective parties, this writ petition is disposed of, giving liberty to the petitioner to file a representation before the opposite party number 3 within a period of 15 days.
Yes.
Within a period of 15 days, giving all the details for release of award amount, land acquisition award amount in her favor. In the event of which the opposite party number 3 shall consider the same in accordance with law and pass necessary order within a period of 2 months. Now, 2 months within a period of 2 months. Communicate the order so and so. All right. Yes.
Item 13.
Item 13 made to your lordship. On behalf of Mr. Chiranjeev Vidyabhushan, the petitioner is seeking a very limited period to seeking a necessary direction to provide one-time settlement benefit to the petitioner. In this case, my lord, 13-4 notice has been issued.
All right.
Liberty may be
13-4 notice has been issued, and petitioner has to approach the appropriate forum in view of all those decisions disposed of. Yes.
Item 14.
My lord, I am filed this petition to challenging the illegal order passed by the RO, DRT Cuttack, and issued a self-proclamation notice by the Annexure 1, my lord, which is fixed by tomorrow for e-auction or auction of the said scheduled land. In the meantime, I have appeared before this.
Which order you are challenging?
I'm challenging Annexure 1, my lord, because I am filed the petition and as well as the request to the bank to produce the up-to-date account statement. But till yet not produced the up-to-date account statement, and I am deposited before as per the Honorable High Court's order. I have already deposited 3.5 lakhs. Thereafter, so after I am deposited 3.4 lakhs before the bank, my lord. But till yet they have not produced the account statement, and saying that
please, don't be in a hurry. You are what you are challenging here.
Challenging the
notice of
Annexure 1, my lord. And I also Annexure 7 I have also given note. Annexure 8 also I have given the OTS application to the bank. Till yet they have not considered the same or received also. They have not received my caution amount. And trying to auction the.
So if you are challenging the DRT order,
yes,
then the forum is otherwise.
My lord, only prayer to settle the matter and produce the up-to-date account statement, man.
That's
the bank till yet not produced the up-to-date account statement and trying to auction the schedule land. We are ready to enter amount.
Once this notice has been issued,
yes.
Have you appeared before because the date is fixed to 17/12.
Yes.
That means tomorrow.
My lord.
So,
my lord, in the meantime, I will approach the bank as well as the RO Cuttack, DRT Cuttack,
to produce the up-to-date account statement, but till yet not produced. We are ready to pay the 8 lakhs and so OTS application which is pending for the opposite party bank. And also I have deposited near about 8 lakhs for the bank.
Fine, whatever you appear and made your objections before this one. So we are not inclined. Otherwise, you can approach the appellate authority that is there. The petitioner, so and so, has filed this petition challenging the notice dated 13/11/2024 of the opposite party number 2, recovery officer DRT Katal, in which he has been in which the petitions have been noticed to appear on 17/12/2024 for drawing up proclamation of sale and settling the terms thereof. The petitioner is since the petitioner can appear before the DRT and file appropriate application challenging such notice, and he is having also the remedy available before the appellate authority. We are not inclined to interfere with the imposed notice, and accordingly the writ petition is disposed of. Yes.
My lord, in the meantime, liberty to file the same, and in the meantime, no course.
He said that you can appear and
Yes.
make your objection, whatever is. Otherwise, you can approach the appellate authority. Yes. Next.
Yes.
Item 16.
The 2 is pending. What is
Great reservations.
Annexure 2 is pending, Mr. Kanungo.
No, my lords, here that is this is not the question, my lords. What had happened, my lords? Initially, I had come earlier challenging Annexure 2.
Mr. Kanungo, you come to your prayer.
My lords.
Item 16. Union of
As
India.
to why appropriate and order shall not be passed to
Item 16.
item 16. My
No,
lords.
item 16.
Item
Union of India is there.
Yes.
Then
It is not that. Okay.
16.
Okay.
16. Yes, my lords.
Surface side.
Prayer, my lords.
Hmm.
Prayer is to set aside the decision of the OP Bank to classify the principal borrower's account as NPA, to declare entire proceedings under 13.2, 13.4 of Surface A as initiated by the respondent bank to be void ab initio, to set aside order dated such and such by CGM Khurda in this case to set aside the sale certificate and pass such other orders.
Yes.
My lords, here, initially, my lords, I am a guarantor. I am not the principal borrower, my lords. I received a notice, my lords, at
32.
page 32, my lords, if your lordship kindly sees.
My lords, the notice was for handing over peaceful possession of the mortgage property secured assets in the account AB Enterprises. Right, my lords? Thereafter, I preferred a writ application before your lordships because I had nothing else. The borrower had
No,
disappeared.
the latest order is 25/10/2024, passed by the CGM Khurda.
Yes, my lords.
And that is annexed to as Annexure 7, right?
Yes, my lords.
So against that, you have the alternative remedy. Why we'll entertain?
No, my lords. I am now on the question of that the account could not have been declared NPA. That has been entertained by the
You
Supreme Court.
raised all those points before the DRC.
This exactly the same points were raised before the Bombay High Court. The Bombay High Court refused to entertain the matter. Matter went to the Supreme Court. The latest judgment of the Supreme Court is that the court has to consider this matter and accordingly declared all the accounts, the account to be classified as NPA as void because they have not followed the mandatory provisions of the RBI. The RBI clearly stipulates, my lords, that an account which is an MSME account, before declaring it NPA, you have to go and you have to first categorize it as under 3 stressed accounts. If you don't do that, and if you don't take corrective measures to, my lords, rectify the stress on the accounts, then the entire procedure under section 13 becomes void. And this is exactly what I'll show your lordships the latest judgment. This has been Pronits versus the Board of Directors of Canara Bank and others. Same, my lords, the Bombay High Court also said you go and raise all the points before the alternative remedy. The Supreme Court said no, this is a question which goes to the root of the matter. If the account is not NPA, then how can you proceed?
This is after Cyril.
My lord?
This is after Cyril.
Yes, my lord, this is the latest.
And Cyril has been followed.
This is on a different point altogether, my lord. This is concerning how you can declare an account of an MSME NPA.
What is the decision?
My lord, this decision is Pronits versus the Board of Directors of Canara Bank and others. Lordship, yes. My lords, at paragraph 2, your lordships may see the last line, that is at page 3, the High Court, without expressing any opinion on the merits or the factual aspects of
Whether
the
that decision has been taken into, that was perhaps the latest one, that
this is 24, my lords. This is 24, my lords, and it's on a different point altogether. How an account of an MSME can be declared to be NPA? Now, your lordships may.
Chandrachud's decision.
Yes, my lords. This is after that. This is after that. This is
whether that has been taken into account.
My lords, that here it is on a totally different point. This is with regard to an account of an MSME, how it can be declared to be an NPA account. If the mandatory provisions under the RBI guidelines have not been followed, then it cannot be declared to be an NPA. So the entire proceedings under 13.2 is void. Everything has to be quashed. This is the ratio of the judgment. In fact, they have underlined it at paragraph 13. Your lordships may place the judgment, my lords.
Yes, it's relevant party.
My lords, I'm placing it from. My lords, I'm placing it from. My lords, paragraph 10, as stated earlier. Lordship gets paragraph 10.
10 years.
Of paragraph 9, thus section 21 read with 35A makes it clear that the directions issued by the Reserve Bank of India to the banking companies are binding on them and they are bound to comply with such directions. As stated earlier, the whole controversy in the instant appeals centers around the notification dated 29/5/2015 issued by the central government in exercise of the powers conferred by Section 9 of the MSMED Act. The said notification contains the instructions for the framework for revival and rehabilitation of MSMEs. The relevant part with regard to the identification of the incipient stress and the committees for stressed MSMEs being relevant are reproduced hereunder. Notification is given.
But in 19, the court is very clear.
My lords, I'm coming to it. The
court has
RBI,
not asked you to come
in
to High
order
Court.
to make the said framework
Legal remedy.
contained, your lordships may come to paragraph 11. The RBI, in order to make the said framework contained in the notification dated 29/5/2015 compatible with the existing regulatory guidelines on income recognition, asset clarification and provisioning pertaining to advances issued to the banks by the RBI, had made certain changes in the said framework.
Ultimately, in spite of
Ultimately,
this,
your lordships may see
say that
paragraph 13.
alternative remedy available, go to the
Paragraph 13,
no, paragraph 19, you come to that.
my lords.
Do not support to remand.
So High Court, it is not remanded, it was given that appellants to take recourse to this one, so remedy available. So you have got
Impugned orders of paragraph 19, impugned order therefore is set aside. That is the High Court's order.
Yes,
Since
yes,
it has been
yes.
submitted by the learned counsels for the respondent banks that in all cases proceedings under SAFESI Act have already been concluded, possession of the respective premises of the petitioners has already been taken over. We do not propose to remand the matters to the High Court for deciding the writ applications afresh. However, since the High Court has not dealt with the other issues based on the factual aspects of the petition, we would clarify it would be open for the appellants to take recourse
That
to
is exactly what
Any
you say.
remedy.
Also.
no,
So
no, my lords. Prior to that, what they have said, your
in
lordships,
spite of that, they could have sent it to the High Court, but they said no, you go to the approach. That is exactly what we are.
they quashed everything, my lords. Your lordships, I'm placing the entire judgment.
No, they questioned, but they have asked you to take legal recovery, legal remedy available to you.
My lords, here,
Had it been so, they would have remanded back if the court has not considered the factual aspects.
the factual aspects, my lords. Here, the proposition of law that has been laid down by the apex court is that you cannot make an account
All right,
NPA without following the
but you are
mandatory
not
provisions.
remediless.
My lord,
You are not remediless.
remediless. I'm not saying that, my lords. But what I'm saying is it can be quashed in writ jurisdiction, my lords. Here, I'm just placing this paragraph 13 for your lordships. In view of the above, it is absolutely clear that the instructions for the framework for revival and rehabilitation of micro, small and medium enterprises as notified by the central government by notification dated such and such in exercise of powers conferred under Section 9 of the MSMED Act as revised by the RBI notification dated 17 March 2016 and the Master's Direction, that is Reserve Bank of India lending to micro, small and medium enterprise sector directions 2016 issued by the Reserve Bank of India and exercise of the powers conferred by Section 21 and 35A.
Yes,
of
Mr.
the Banking
Kanungo,
Regulation Act.
here the court has nullified the action of the bank.
Exactly, man.
So let it be taken. You can take it. What is there? The action of the bank is not in accordance with the Reserve Bank guideline.
The action of the bank,
Vis-a-vis the MSME.
no, they
scheme.
say that you cannot declare an account
Yes.
NPA. If an account is not NPA, my lords, can they proceed under Section 13(2)?
But are you stopped to take this plea in the proper remedy?
No. Sir, my lords, now the entire thing is without jurisdiction. Your lordship, I'm just, let me place it. Having statutory force are binding to all scheduled commercial banks licensed to operate in India by the Reserve Bank of India as stated in the said directions. It cannot be gainsaid that the Banking Regulation Act 49 basically seeks to regulate banking business and mandates a statutory and comprehensive and formal structure of banking regulation and supervision in India. Section 21 and 35A of the said Act empower the Reserve Bank of India to frame the policy and give directions to the banking companies in relation to the advances to be followed by the banking companies. Such directions have got to be read as supplement to the provisions of the Banking Regulation Act and accordingly are required to be construed as having statutory force and mandatory. Now, thereafter they go, what is, your lordships will see.
No, they have quashed the entire order of the High Court.
Yes, my lords.
So 19 is the
relevant
paragraph.
No, thereafter your lordships will see, as transferring from the said instructions, directions, the entire exercise as contained in the framework for revival and rehabilitation of MSME is required to be carried out by the banking companies before the accounts of MSMEs turn into NPA. It is true that the security interest created in favor of any bank or secured creditor may be enforced by such creditor in accordance with the provisions contained in Chapter 3 of the SARFAESI Act, and that as per Section 35 of the SARFAESI Act, the provisions of the said Act have the effect, notwithstanding anything inconsistent therewith contained in any other law for the timing in force or any instrument having effect by virtue of such law. However, pertinently, the whole process of enforcement of security interest as contained in Chapter 3 of the SARFAESI Act could be initiated only when the borrower makes any default in repayment of
we
secured
don't
debt or
disagree with
any
you. The
installment.
action of the bank has been completely nullified.
Yes, ma'am.
And the court is very much conscious of the fact that a writ petition has been disposed of.
Yes, ma'am.
And the court consciously has said that we are not remanding the case to the High Court. Because there are some factual aspect which has not been decided by the High Court, can be remedied in
on fresh issues, ma'am.
not by High Court. Not by High Court. Not by
19 again I am placing before you. The impugned order therefore is set aside. The High Court refused to interfere. That order is now set aside. It has been submitted by the learned counsels for the respondent back that in all the cases the proceedings under SARFAESI Act have been concluded and possession of the respected premises of the petitioners have already been taken. We do not propose to remand the matters to the High Court for deciding the writ applications afresh. However, since the High Court has not dealt with the other issues based on the factual aspects of the writ petitions, we clarify it would be open for the appellants to take recourse to any remedy
available. Remedy available.
as may be legally available to them for agitating the issues not decided by the High Court in the impugned order. So the issues which had been decided by the High Court in the impugned order was you go to the statutory remedy.
Yes, that is what is.
But
that is the
factual issues, like the High Court can still decide. That is exactly what the High Court order is
what
saying.
made the court not to remand it? To decide the factual aspects, whatever has not been decided.
This was on a pure question of law. The factual aspects were never argued before the court.
With the petitioner, so and so, for a inter alia, for a direction to set aside the order dated 25/10/2024 passed by the Learned Chief Judicial Magistrate Khurda in miscase number 190 of 2024. The main ground that has been taken by
this is only to the issue decided by the High Court without
is
addressing
that,
other issues. Paragraph 3.
there is a illegal and
Just before
arbitrary
your lordship
actions
passes
taken
the
by the
order.
opposite party number bank in classifying the loan account as non-performing assets, which is in clear violation of the mandatory norms as prescribed by the RBI and MSME Ministry. In support of the contention, the Land Council for the petitioner has placed reliance on the decision of the Honorable Supreme Court in case of Mrs. Pro-Nits versus so and so. Mr. Kanungo placed paragraph number 13 of the said judgment, which reads as follows. However, in the Honorable Supreme Court has been pleased to hold in paragraph 19 as follows. In view of the decision of the Honorable Supreme Court in case of so and so, since alternative remedy is efficacious remedy is available to the petitioner to challenge the impugned order under so and so, in view of the decision of so and so, we give liberty to the petitioner to raise all these points taken before this court, before the learned so and so, in the event of which same shall be adjudicated in accordance with law. It is made clear that we have not expressed any opinion on the merits. Yes.
Well, just before we part, my lords, your lordships may see paragraph 3 also.
Yes.
The learned counsels for the parties in the appeals have also restricted the submissions only to this issue, whether the account can be declared as NPA or not. have not raised
We
the
have
further
given liberty
factual
to
issues.
That's a
raise-
point of law only has been decided.
Yes, my lords.
Here you can raise all these points. Yes, next.
Oblige.
Next.
Item 17.
In course of day, we are filing the requisite units.
The land council petitioner submits that requisites for issuance of notice on the opposite party number to
4 to 42.
4 to 40.
Lordship, I'm appearing for the respondents.
No, 4,
Deceased,
4 to 42 you are appearing.
yes, deceased number 5, 13,
No.
20, and 38 are dead.
So you are not appearing for all the opposite party.
We are not appearing for all.
କାହା ପାଇଁ appear କରୁଛନ୍ତି
For
କୁହନ୍ତୁ?
5,
Respondent number
We are appearing for everyone.
all respondents.
But deceased 5, respondent number 5, 20, 13, and 38 are dead.
Oh,
We have no instruction regarding them.
5 who are dead, 5,
5, 13,
13,
20, and 38.
5, 14, 20,
13, 13.
1, 4. Acha.
1,
5,
1, 3, sir.
1, 3,
1,
13.
3. Acha. 5, 1, 3, 20, and 48. Right?
38.
38. Acha, 38.
38.
38. They are dead according to you.
There,
So
there.
you take instruction, rest of the opposite
Well,
party.
we have already filed IA. The IA already. I've already filed IA, and IA already notice has been issued, Your Lordship. But we have in course of day we are filing the requisite.
In IA number
IA
564.
558 of 2023.
558.
Lordship. IA
That
number.
is pending since.
ଓ ସେଗୁଡାକ ସେଇ ଯୋଉ ଏମାନେ legal
That
heirs
is,
को
legal heir.
5A, 5B, 5.
Take file the requisites for the interim application during course of the day. Out of this matter after the notice is held sufficient. As per the order dated so on so IA notice would have ହେଇଥିଲା ସେ requisites file କରିନଥିଲେ ଆଜି file କରିବେ. Yeah.
Interim order to continue, Your Lordship.
There is there.
Your Lordship.
Order number?
Order number 13, 17/8/2023.
ମଝିରେ ନଥିଲା ଫେର
That is order number 17, Your Lordship.
Order number
1523.
Lordship.
Interim order passed earlier shall continue till now. So this order was passed on 17/8/23.
Lordship.
So we are vacating the interim order and we are dismissing all your interim applications. So you are enjoying the interim order relief and you are not taking even steps for filing requisites.
He is not able to speak. In fact, the concerned clerk who was on that relevant date, he was suffering from dengue. But that's the reason we could not take any step.
No.
Suddenly it came to our notice that when he recovered after a month after.
No, that is not a ground. We are dismissing.
Now, Your Lordship may not vacate the interim order because the reason being that's it. In fact, it escaped our notice. Otherwise, normally after taking interim order, we do not.
That has happened, Mr. Rotha, in this case.
This is an unusual event. This is
17/10, 1 year, and
may impose some cost on us because it's an unusual event. We, in fact, wrongly, without any intention, this has happened. The clerk said yesterday, I told him.
Deposit 25,000 in the advocate's welfare fund in the High Court. That would be subject to the continuance of this interim order. The interim order was passed on 17/8/2023. And it was directed to file requisites in all the interim application, but no step has been taken. And the Land Council for the petitioner submits that in course of the day, the requisites will be filed and the interim order may be permitted to continue. Since there is already a delay of 1 year and 4 months in the compliance of the order dated 17/8/2023, let the petitioners deposit a sum of cost of rupees 25,000 in the High Court's Advocates Welfare Fund and produce the receipt put of this matter day after tomorrow. That is on 18th of December 2020. Yes.
Can I put a request, bro? Subject to Lordship will consider it. Man is of Sundargarh. So we don't
ask him. This order has been passed.
No, we will
otherwise
definitely ask him and promptly will take steps. Lordship may give us little more time for that. Because your Lordship is directing day after tomorrow. Lordship may just
let them get something for the Xmas holiday. Yes, next.
Item 18.
Yes, item 18.
This is a review application, man.
Yes.
The petitioner is asking for review of your Lordship's judgment, precisely on the ground that there is error apparent on the face of record itself, man. The writ petition and judgment relating to Lord selection and appointment of typist in the Judgeship of Kendrapada.
Which is the order you are?
Annexure 1, page 13, it starts, my lord.
Yes.
In a nutshell, should I speak, my lords, what's the issue about?
Yes.
There are 3 posts advertised, my lord, for the post of typist, junior typist in the Judgeship of Kendrapada. One for SCBC, one is unreserved, and one is SC. Now, as per Rule 7.4, a common panel is to be prepared. One consolidated merit list is to be prepared. Consolidated merit list, a person who is SCBC and has availed relaxation, he was heading the list. He was serial number 1.
On merit.
No, it's a consolidated list. On merit, he was 1.
That is what I'm saying.
Yes,
on merit.
Right, your lordships are correct. I am at second. I am also SCBC. The third person you are is third. So I have secured, I am the second person has secured in general competition more than the unreserved person. The first one, in the consolidated list, first one, he has availed age relaxation in view of the couple of judgments from the Honorable Supreme Court. If you avail any concession in age, mark, eligibility, or fees, that amounts to availing reservation. So there are couple of judgments I have with me.
Right.
Now that person availed concession. So he got reservation facility in SCBC. But me, I have secured higher than the UR person. So in view of Indra Sani and other judgments, I should have been adjusted against UR. Am I clear, my lord? I have secured higher than the UR. So I have not availed any concession. So I should not be pushed to SCBC category because I am more than the UR candidate. That is the simple analysis here. But this the judgment is that since there are separate merit lists prepared for each category, I am forced to remain in SCBC despite availing securing more mark in against the UR person.
So why it has come for orders? Orders against you have not filed the certified copy of the order. That is why it has
The
come
judgment. But that I'll do.
The Learned Counsel for the petitioner takes 1 week time to file the certified copy of the input order. And thereafter the stamp reporting shall be made and the matter will be placed for admission. Yes.
Right.
Item 19.
And at item 19, there is a typographical error in concluding para of your lordship's order dated 27/11. In my eye, I have annexed that order page 8, my lord, running page 8.
What is that error?
Hide annexure 4. That should be annexure 3 series.
Annexure 3.
3 series. There is no such annexure as 4.
Okay. This interim application has been filed for modifications of order dated 27/11/2024. The Learned Counsel for the petitioner submits that inadvertently in place of annexure 3 series, comma, in the order it has been mentioned as annexure 4. Therefore, the same may be corrected. Land Council for the state has no objection. Accordingly, the order dated 27/11/2024 is modified to the extent that in the operative part of the order where annexure 4 has been mentioned, comma, the same shall be read as annexure 3. This part of the order shall remain unaltered. Accordingly, interim application is disposed of. Yes.
Item number 20. Please, Your Honor, Lord, the modification of the order, Lord. I have made a party to the Tahsildar Katak, Lord. Millard wrongly type Millard Tahsildar Konase Millard. A pre Millard insert the Tahs.
Should be Katak.
Again.
Tahsildar opposite party number 4 is okay. Look on IN number so and so. This is an application for modification of the order dated so and so. The Land Council for the petitioner submits that the what I would have
Where is it?
Tahsildar says, Millard, my name is Millard Santosh Kumar Sir Millard, but it is wrongly mentioned that Prema Devi.
Which order he was?
Millard, the petition is Premadi has filed this writ application petition, Millard. But in place, Millard, in fact, Millard Santosh Kumar Sir filed a petition, Millard.
Your petitioner is?
Santosh Kumar Sir.
That is there.
Wrongly mentioned is Premadi lekha is it.
Kahin?
अच्छा अच्छा वो जो second year
Oh, ये जो paragraph.
Again,
देखो the IN number so and so it has been filed for modification of the order dated so and so. The Land Council for the petitioner submits that in the second paragraph of the order dated 20/11/2024, the petitioner name has been inadvertently mentioned as Prema Devi, inverted comma in place of Santosh Kumar Sahu. And in the operative part of the order, the Tahsildar Onas has been mentioned in place of Tahsildar
Sadar Katak.
Tahsildar Sadar Katak. And therefore the same may be corrected. Land Council for the state has no objection. Accordingly, the order dated so and so is modified, and in the second sub-paragraph, where the name of the petitioner has been mentioned as Prema Devi, the same shall be read as inverted comma with Santosh Kumar Sahu. And in the operative part, where it has been mentioned as Tahsildar Kanas, the same shall be read as Tahsildar Sadar Katak. Rest part of the order shall remain unaltered. Yes.
Item number 21.
Wait, please, my lord. Petitioner before your lordship, my lord, then LDC. The last occasion your lordship had asked my learned friend for the settlement.
No, for ICR.
For ICR to take instructions because of the my lord's order at page 8.
No, this case was supposed to be listed on
30.
13/125.
The difficulty is the new development is this, my lords. On 10th, my lords, your lordship passes this order. Order
Yes.
number 1. Lordship, kindly bear with me, my lords. On 10th, your lordship directs him, the learned counsel for the state submits that since the petitioner was terminated from service on 8/3/17, which was under challenging the OA, he seeks some time to obtain instruction about the authenticity of this particular document. That is the office order dated 3/11/2023 and file an affidavit to that effect by the responsible officer. Now, 3/11/2022 is the document which says that the DPC has recommended for my successful completion of the probation.
Yes, we have a doubt on that.
That document, yes.
Yes, so that
Yes.
is exactly.
That is why we have.
So that is that. So your lordship said, how did I get the order? This document was given to me. Your Lordship may kindly.
No,
This,
whether it is authentic document or not, that is the main.
yes, sir.
Otherwise,
Annexure A1. A1 is the A1 is the proof
no,
that
that
Mr. Lord-
document, we still remember that it appears that it is a forged one because all these things. So that is exactly what the reason why we asked him, because
Yes,
he has
exactly.
already
Great,
been terminated
great.
since long, and
Okay.
then this order was passed that
Yes.
as
Confirmation.
My lord, this is that your Lordship may kindly come to page
Let him,
7.
no. What is the purpose of advancing the date when the case is posted to?
Purpose of advancing is annexure A2. A2.
No, that you raise on that. We don't find any like on since the date.
No, A2. Lordship may kindly the IA A2.
Please argue this matter on 13/11. The date is
The,
13/11.
after your Lordship's order, after your Lordship's order, they have revived the order of termination, which was stayed by the tribunal all along. And I have been in service from 11. For the last 11 years, I've been working, my lords.
Yes, this
For the last 11 years.
So appropriate order. This will be also considered on 13/11/2025. Yes, next.
I have a little submission, my lord.
Yeah.
That in the there is the additional standing counsel for that is that should not be there because I am the counsel for ICR.
You are for?
The additional counsel for opposite party, but I am say the counsel
You are for ICAR.
ICR. Not additional.
So you have to take the instruction.
I have
in place of
Arvindo Mahanti লেখিবে এটা additional standing
No,
counsel
no,
mention
I'm-
হবে advocate for the opposite party number 1
Yeah.
Yes.
Now, after 11 years now, I'll be out of employment.
See that.
And it was stayed. This order was stayed all along, Manoj. For the last 11 years, I've been continuing. That is the whole difficulty, Manoj, why we want to advance the date. And also, Manoj, to satisfy your Lordship, Manoj, Lordship may kindly have a look. For a second, your Lordship may look at page 7, annexure A1 of my IA. That is how I got the document.
We have to be satisfied on that particular document. We'll see that.
Yes, yes, that is the satisfaction, Manoj. So record your Lordship's satisfaction. It's there. I produce the material, Manoj.
Yes.
Your Lordship may kindly have this IA.
All right. 13. Next.
Item number 22. Well, it's item 22. Your Lordship has directed me to take an instruction with regard to the financial burden to be taken by the state government. Whereas I have received the instruction where, my lords, the state government has categorically instructed that state government shall not burn any additional financial liabilities by the OSRTC, my lords. If your Lordship will be kind enough to give me one opportunity, I'll file the affidavit. Where, my lords, state government, may I read that portion, my lord?
No, you filed the.
As your Lordship,
they have
please.
a right to do this.
Yes, my lords. This just
so you
short.
have already received the instruction.
Yes, my lords.
In the form of an affidavit, you are supposed to file. All right, file it.
Yes, my lords.
The
My lords, insofar as
Land and Council for the state submits that in terms of the order dated 20/11/2024, he has received instruction regarding the status of claim of 16 numbers of retired employees. However, he wants to place it by way of an affidavit and seek some time in that respect. Put up this matter, January date rakhive, second week. Affidavit be filed in the meantime of giving copy to the Land and Council for the respective parties. Yes.
item number 23.
Yeah, this one praying for adjournment.
20. Yes, just a minute. Item 23.
Yes.
You are for the
Respondent. I'm on behalf of Gautam Acharya, senior counsel. Senior out of
what was the order passed? Let us see.
Lordship had taken up it earlier, but because of the pagination matter, my lord, it could not be taken. Now after pagination, it has come. So it is relating to the accountant general's the objection to the. Adjournment. Come after.
Mr. Manoj Mishra and senior advocate is present. You are for the petitioner. No?
I am for the petitioner.
For the petitioner. A mention is made on behalf of Mr. G.K. Acharya, land senior advocate for opposite party number 2 and 3 for adjournment on consensus of both the parties. This is January second week.
The name of Mr. Kali Prasanna Mishra is to be dedicated.
अच्छा मिस्टर केपी मिश्रा को ना
हाँ फिर फर्स्ट resolution.
Oh, there are two matters.
There are three matters connected.
There are three matters.
Three matters.
First matter is the list.
Okay, এটা রইব ଆମର ফার্স্ট রে মিস্টার কেপি ମିଶ୍ରଙ୍କ ନାଁ ରହିବ ତାପରେ ସିନିୟର ଆଡଭୋକେଟ ତାପରେ ଯୋଉ ଦିଟା ମ୍ୟାଟର ମିଷ୍ଟର ମନୋଜ ମିଶ୍ରଙ୍କ ସିନିୟର ଆଡଭୋକେଟ ନାଁ ହେଲା ଆଉ ଏଇ ମ୍ୟାଟର ଗୁଡାକ ଏକାଠି ଆସିବ ବୋଲି ଅର୍ଡର କରିଦେବେ ପ୍ଲିଜ ଦିସ୍ ମ୍ୟାଟର second week of January.
Entry model 14 million.
Entry model
We commencing 9th million. We
we
commencing
commencing second week.
Item number 24.
Item 24, Mallards, it was fixed for hearing subject to filing of a written note, Mallards. I beg apology, it was with my learned senior, Mr. G.
For the state submit that
And I-
intends to file written note of submission by next round, giving copies to the land council for the respondent is Mr. Otto.
Yes,
You have not
Mallards, this file was assigned to Mr. G, my learned senior, but now I have kept the file with me, I have retained with me, I'll file it. Mallards, Lordship may fix any date, Mallards, within 2 days I'll prepare
Yes,
it. Mallards.
Mr. Otto, what do you say?
I must say, I cannot have an objection because your lordship's direction therefore to give a written note of submission. But if that must be within a scheduled time, my lord.
Mallards, any day your Lordship give, Mallards, I'll do it.
The land council for the state seeks some more time to file the written note of arguments, a written note of submission. Mr. Jan Kumar Rathal and senior advocate is present. List this matter. Say second week ratio. Second week of January. Second week ro mane se jo
Second week of January.
January 2020. Not
Not
tarik na kete uda.
My lord. That is 3, 4, 5.
This matter has already been heard.
January is the second week, my lord.
This is for review.
25 and 26 reflect the name.
Second week around the 6th January. Mr. Otto, it will come on 6th of January
Yes, sir.
2025. All right.
Yes, sir. My lord, respondent number 25 and 26 reflected the name of SK.
Respondent number
25, 26.
कौन क्या हो जाएंगे?
SK Purohit name of reflected.
SK
Purohit.
फाइल करछन दिवी नामा
Already file ଅଛି. Reflected the.
Oh, his name is already there. Cecil, oh, you want to reflect.
अच्छा Mr. Sisir Kumar Purohit
Presence is to be reflected.
land council for the opposite party number
25 and 20.
25 and 26 is
It's
present.
from the university. That is
Yeah.
Item number 25.
Your lordship may see the order dated 19/6/2024 passed in WPC number 18973 of 2020. There are two matters. One is writ petition, other one is WA. Your lordship may see the order dated 19/6/2024 passed in the writ petition. Shall I read it, your lord?
Yes.
This matter is taken up through hybrid mode. Heard Sri So-and-so, learned counsel for the petitioner, and Sri So-and-so, additional government advocate for the state opposite party. Sri So-and-so, learned counsel for the petitioner, contended that the order dated 6/3/2020 passed by this court in WA number 6 of 2020, by which this court set aside the order dated 6/12/19 passed by the learned single judge in WPC number so-and-so, and directed the opposite party 1 and 2 to take step to invite tender. I lay stress on this, my lord, to invite tender, giving generic ingredients of the medicine without using any brand name after 24/5/2020 in terms of the relevant rule applicable to the field, which would be beneficial for micro and small enterprises of Odisha, registered with the director of EPM Odisha, is unworkable as it is contrary to Rule 4.3 of the rule for rate contract with micro and small enterprises of Odisha 2014. He further contended that Rule 4.3 prescribed that a rate contract in respect of specific store item, services not in the exclusive list, and manufactured provided by the local MSE shall be finalized by the Director of Export Promotion and Marketing on the basis of the competitive offer, tender, called for them. The state government, department and agency under the control of the state government shall purchase the rate contract item and avail services from the rate contract holding micro and small enterprises at the rate contract price without inviting tender. Here also I will stress, my lord, without inviting tender. But in the order dated 6/3/2020 passed by this court in WA number so and so, direction was given to the opposite party number 1 and 2 to take steps to invite a tender giving generic ingredients of the medicine without using any brand name according to him, since such direction is contrary to rule is unworkable. So now this case has been filed seeking clarification by the state. In fact, they have sought for clarification on only one front, my lord.
Yes.
Two front clarification is required. First is that since the item which I manufacture is a rate contract item and it is within the fold of rate contract, once it is brought within the fold of rate contract, as per the rule, it can be procured only from the firm having rate contract. It cannot be put to tender. That's the rule. Second, there is no generic name of the pillars of powder, my lord, which has been shown by the director of export promotion to the director of other director, my lord. They say there was a query after the order of this honorable court. There is a query that give me the name of generic name of the medicine.
Who has filed this interim application?
We have state has filed,
The state was supposed to get the clarification because this cannot be obtained through tender. It can be obtained through rate contract.
IA number 578 of 21, flag F by 5, my lords. Annexure F by 5.
Flag F. You have filed this interim application in the writ petition.
My lords, in the writ appeal, because the writ appeal order dated 6/3/2020.
Mr. Sharma, who has filed this interim application in WPC?
Which interim application, my lord?
There is an interim application for appropriate direction in WPC number 18973. Have you got the cause list with you? Please see that who has filed.
It was filed along with the writ petition. No fresh IA has been filed. It is of year 2020 when the writ was filed, my lord.
Okay.
No fresh IA has been filed by me. Only IA filed by the state is in the WA because they are seeking clarification of the order passed in WA.
Writ appeal has already been disposed of.
Yes, yes, it's a filed to the writ petition. I have annexed the order. The last paragraph is objectionable, my lord. Last paragraph of the order passed in the writ appeal is objectionable and unworkable because this honorable court directed they put this item to tender and give the generic name of the product, my lord. The state government in the Department of Export Promotion says there is no generic name of the pillars of powder which I manufacture.
Just come to the operative part of
yes,
that.
Yes. Page 41, madam.
In view of the such stand taken by.
Since the time period of validity rate contract in respect of pillars of powder is going to be elapsed on 24/5/2020, the authority also admitted the counter recipe that the rate contract is valid and it will be continued till 24/5/2020. And neither the appellant was made a party in the writ petition. Appellant means me, Lord. Nor the petition, nor the vital documents like Annexure 7, 8 were placed before the learned single judge. And by virtue of passing of the impugn order, which has gone against the appellant, principle of natural justice had not been followed. We set aside the impugn order dated 6/12/2019, passed by the learned single judge in so and so, and direct the respondent number 1 and 2 to take steps inviting tender. But this is unworkable because the rule says it has to be obtained through rate contract form. Tender giving generic ingredients. This is also not workable because there is no generic ingredients of the pillars of powder which I manufacture.
Why this type of order was passed? Because there must be some contention raised before us.
The contention I raised is I annex the rule, my lord. The rule says once an item is brought within the fold of rate contract.
Please see the counter affidavit which has been filed and what is the government's taken there.
Support my case.
Just come to that. Counter affidavit, page number, yes, a counter affidavit has been filed by the respondent number 2, so and so.
I request your lordship to see Annexure 7, page 46.
No, you just come to
Yes,
that.
yes.
There must be something for which we pass that order. It's not that.
The OP3 has filed counter.
No, you come to that portion. A counter affidavit has been filed by the respondent number 2, Director Export Promotion and Marketing Odisha Bhubaneswar. Say paragraph ko asundu. That is in page number page number 6. 6 of the order.
Counter affidavit has been filed by the respondent number 2, Director Export Promotion and Marketing Odisha.
Yes.
On behalf of
Please use the mic.
A counter affidavit has been filed by the respondent number 2, Director Export Promotion and Marketing Odisha, Bhubaneswar, on behalf of the respondent number 1, 2 and 4 in the present writ appeal. And it is stated that paragraph 6.1 that BG Pharmaceutical Limited, the appellant, is a registered unit under the Directorate of Export Promotion and Marketing Odisha for manufacturing of Ayurvedic medicine Pilasab as per drug license number so and so by the Director Ayush Odisha Bhubaneswar, and Pilasab is one of its manufactured items and thus admitting the claim of the appellant. So what I am saying, my lord, this item under Annexure 3 to my writ has been brought in within the fold of rate contract. And once there is a rate.
Please continue.
Yes.
Continue, please.
Yes, sir.
However, in
paragraph 7 of the counter affidavit, it is stated that rate contract has been concluded in respect of store item Pilasab, a proprietary Ayurvedic medicine with specific composition supplied by the Director Ayush for rate contract, and since it is a proprietary Ayurvedic medicine manufactured by the appellant, other MSC would be deprived of the benefit of the rate contract as they cannot manufacture the item in the brand name of Pilasab with the same composition. As a result only, MSC, the present appellant, would be benefited in the state of Odisha. Further, it is stated that state government is implementing various policies such as MSME development policy, industrial policy resolution, and rate contract rule. This is important, rate contract rule matter, for the benefit of the large number of MSC. And in the instant, only one unit, the unit of the present appellant, is benefited since the store item under the rate contract is a proprietary firm item. Sorry, my lord. One of the basic argument in this case is that, my lord, state government consciously took a policy decision to bring this item within the fold of rate contract Annexure 3. It is a decision of the state record. And the rule says once the item is brought in within the fold of the rate contract, that item cannot be procured through tender. It can be only obtained from firm having rate contract. So now there is an advertisement for the purpose of entering into a rate contract, not for the supply of particular item. That rate contract firm is supposed to supply the item.
No, because once this name is given, then it is only produced by you will be benefited. Whereas the same composition
no, my lord. The advertisement is not for the purpose of supplying any particular item. The advertisement is for the purpose of entering into a contract for the purpose of rate contract. That's all. If you
for example, suppose what a blood pressure medicine. तार जदि आम गोटे कंपोजिशन देबू एवं ये करू जे आम ब्लड प्रेशर मेडिसिन चाहूँ एई कंपोजिशन ताहले विभिन्न कंपनी जो माने सेई कंपोजिशन ब्लड प्रेशर मेडिसिन करछंती दे विल अप्लाई फॉर दैट एंड देयर विल बी आमे जदि गोटे पर्टिकुलर कंपनी नारे दबु जे एई एटा तले से कंपनीटा तो आपन
नॉट कंपनी
फिलोसॉफटा होची आपनकर एटा
फिलोसॉफ by there is no advertisement. My lord, advertisement is for the purpose of entering into a contract for rate contract. That's all. They invite application that you apply not for the purpose of supplying Pilasab powder. It is for the purpose of entering into a rate contract. That's all. A firm having particular qualification can enter into a rate contract. Once there is a rate contract, these items can be procured from these rate contract firms, my lord. They cannot be put to tender. So it is not that I am supplying this particular medicine. The state government, first of all, will have a rate contract with me.
We again, because if a detailed order has been passed, we have to again go through it. Because
the government himself writing Annexure 7, your lordship may see Annexure 7, page 46. Government is saying there is no generic name of the Pilasa powder. Page 46.
So who is the manufacturer of Pilasa?
Pilasa powder I am manufacturing.
Now, what is your name as farm name?
BG Pharmaceutical, madam.
So BG Pharmaceutical will be one of the intending person, a farm, to apply for the EPM rate contract.
Yes.
Not for Pilasa.
Advertisement was that money. If you also Annexure 2, Annexure 2 to the writ petition, my lord. The advertisement was for the purpose of entering into a rate contract, not for the purpose of supplying the particular item.
If you come to paragraph number, page number 2, just of that order which you are placing, our order, the writ petition was filed. Just read it out, that particular paragraph. Page 2 of the order.
Yes. Writ petition was filed by the respondent number.
Go a little slowly. Yes.
Sorry. Writ petition was filed by the respondent number 6, Suryakant Panda, seeking for a direction to the opposite party 1 and 2 to stop illegal procedure and work for selection of offer for supply of Ayurvedic proprietary Pilasa, and to allow him and other EPM registered Ayurvedic manufacturing unit of Odisha to supply pharmaceutical, classical, generic composition medicine for the equal and better treatment of the specified diseases, cancelling the specified brand name philosophy of a registered firm for treatment of the patient suffering from orso throughout the Odisha, which not only would save the lives of large number of associated educated youth employees, but would also enhance the competition to manufacture better quality of Ayurvedic medicine for the truth for future interests of the people of Odisha.
Go on reading. Yes.
The case of the petitioner, respondent number 6 here in the writ petition is that he being the proprietor of a EPM is reserved only for that particular registered firm which clearly deviate the EDL in respect of Ayurvedic and Unani drugs prepared approved by Health and Family Welfare Government Odisha so and so so and so. For all the entrepreneurs being agreed by such offer order, the respondent number 6 raised objection and approached for acceptance of letter of director of EPM and some subcommittee resolution dated so and so for selection of store item Ayurvedic medicine human for bringing it EPM rate contract fold as per Odisha MSMED policy, in which it was unanimously decided for inclusion of classical Ayurvedic medicine in rate contract fold. When the respondent number 6 did not receive any response, he made representation to the respondent number 1 and 2 to take step to cancel the offer for medicine Pilasa for its inclusion in rate contract fold and allow it and other EPM registered Ayurvedic manufacturing unit in rate contract fold.
All right, we'll take up this matter tomorrow.
Weekly list, item number 1.
My lord, I am appointed by legal aid, my lord, and I have already received the paper book. Kindly be taken as a hearing matter, my lord.
Paper book can you supply to the state? Paper book not.
And there is a noting that
Yes, yes.
regarding whereabouts of the appellant, my lord.
That report is
Awaiting.
yes, no, already received.
Here, sole appellant.
My lord.
এটা কোন read করতে পারলাম ভুলে লেখেন sole appellant.
এটা ওটা ভুললে লেখায়
Manoj Das so and so was admitted in sub jail in connection with so and so. Yet convict was transferred to circle jail. Baripada for confinement. So he is in custody.
Yes, in another case.
So you have received your paperwork. You
Yes,
have
yes,
not
yes. None.
You have also received.
Yes, yes.
So why are you not getting ready after this Xmas holiday? We can take up this matter for hearing. Is it direct evidence or?
Yes, my lord. Eyewitness PW1 is the eyewitness. Injured witness PW4 and 5. Double murder.
Acha. They have supported the prosecution.
Yes, my lord.
So yes, Nanda, what do you say? Is there anything in your favor that?
My lord, ମୁଁ ଆଉ ଦେଖିନି କାହିଁକିନା ଏଇଟା ଏମିତି ହେଇକି ଆସିଛି ଅର୍ଡର୍ସ ରେ ବୋଲି ମୋ ପାଖରେ ବି ସେ ବେଲ୍ ପିଟିସନ ବିଷୟରେ କିଛି ନଲେଜ
No,
ନଥିଲା।
bail ନାହିଁ ଆପଣ ତ hearing ଆସିବ
ହଁ
2006
ଆଜ୍ଞା
ମସିହାର କେସ୍ ଆଉ ପେପର ବୁକ୍ ଇଏ କରେন ଆପଣ hearing ପାଇଁ ପ୍ରିପେୟାର ହେଇଯାଆନ୍ତୁ।
ହଁ
ଲେଖନ୍ତୁ the learned counsel a name of Mr. Ravi Narayan Mishra shall not be reflected in the cause list henceforth ହେଲା ଏଇଟା ଭାଇ କାଟି ଦିଅନ୍ତୁ। Nanda learned counsel submits that she has received the paper book but she has not gone through the same and the matter may be taken up after ensuing Xmas holidays for hearing. The learned counsel for the state also submits that he has received the paper book copy. Put up this matter. Second week of January 2025 under the heading of hearing list.
Item 2.
By the way, खाली लिखी दियंतु peruse the whereabouts report submitted by the so and so at flag C and flag D. It all is लिखी Okay. Yes, item number 2.
My noting is that my lord, the same appellant has filed another criminal appeal number 75 by 2011,
That has
which
been
was
disposed
disposed
of.
of.
So why have you again filed? देखिए कौन है इसकी result criminal appeal open judgment delivered accordingly the matter is कौन है judgment कौन है High Court. We do not find any merit in so on. Dismiss it in the appeal. Only good of challenge. Same judgment. Without the judgment and all related
26/9/16.
মানে ADJ 17/12/2009 কামাখ্যানগর কামাখ্যানগর এইটা হিসেবে যাক এই যে কথা বলছি কামাখ্যানগর সিটি সেশনস 169/2008 criminal judgment
judgment नाही काय हा এটা ହେଲା सर ये नहीं सर ଏଇଟା ସେଇଟା ମୁଁ ଭାବୁଛି ଜେସିଆରଏଲ ଟା ଆପଣ ବାହାର କରିଛନ୍ତି ମୁଁ ସିଆରଏଲ ଜେସିଆରଏଲ 6ଟାକୁ ଦେଖୁନି ତାର ଜଜମେଣ୍ଟ ହେଇଥିଲା SR Boydar SR Boydar SR Boydar ହଁ ତାହେଲେ ସେଟା ହେଇଛି ତାହେଲେ ସେସନ୍ସ କେସ୍ ନଅଟା ଜଣା ପଡିଯିବ um, 17th December 2009.
ठीक आओ ये unit number criminal trial number
16/2008, 68/2008, 169.
2008 public criminal trial
68/2008.
समान अच्छा
ठीक है let on
Arising out of GR 350 of 2008.
It appears that the appellant Prashant Pradhan has preferred JCRLA number 75 of 2011 and in the said criminal appeal the judgment has already been pronounced since 26/9/2016 pronounced on Korean and the criminal appeal was dismissed and the judgment and order of conviction and sentence dated 17/12/2009 passed by the additional session judge Kamakhya Nagar in criminal trial number so and so was confirmed. In view of such state of affair, this JCRL number 6 of 2010 is disposed of. Yeah.
Item 3.
Item 3, the present JCL also disposed of on 3/12/2024.
3/12.
Judgment dated May 3/12.
Correction. Oh.
କଣଟା ନୋଟ୍ କଣ ଦେଇଛନ୍ତି କିଏ ପେମେଣ୍ଟ କରିବ
ସେଟା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଦବ ଗଭର୍ଣ୍ଣମେଣ୍ଟ
କଣ କରେକ୍ସନ ହବ କଣ ଦେଇଛନ୍ତି ନୋଟିଂ କରି
ନୋଟଟା କାହିଁକି beneficiary listing number is forwarded to additional district. Note कहीं किसी ने କିଛି ନାହିଁ
କଣ କରେକ୍ସନ ଟା ମୁଁ ଲେଖିବା ତ କଣ କରେକ୍ସନ ହବ
କରେକ୍ସନ କଣ ହେଲା
judicial shall place a note properly. That's what's fine. Let me know though this matter has been listed regarding corrections, but the details have not been mentioned therein. Register judicial is requested to place a proper note.
Details of the nature of correction.
Details of the nature of correction.
Item 4.
Please, Your Lordship. Lord, appellant number 3 is praying for bail. This criminal appeal, my lord, is in custody since 11/12/2011. Is more than 13 years, my lord.
Yes. So as it appears that this criminal appeal, we have already granted bail to appellant number 1 and 2.
All are released on
1,
bail.
2,
Except 3. All are released
4,
on
5
bail.
released on bail. Earlier, the bail application of the petitioner Basant Marandi
This is the
was
present
rejected on merit on
it was
24/3/2015.
15.
24 to
24/3/2015.
In this case number 1573.
In this case, custody certificate has not called for.
No, they were in custody since when? Joda
11.
जो bail दिया है ची.
My lord.
The present appellant is standing on similar footing other with the 1 and 2 standing on.
ସେମାନଙ୍କୁ ଯେ 10 ବର୍ଷରୁ ଥିଲା ବୋଲି ବେଲ୍ ଦିଆ ହେଇଛି ସମସ୍ତଙ୍କୁ ସେ ଅର୍ଡର ଡେଟେଡ୍ ଆମର A 7/10/2024 ରେ ସେଟା that was filed by the appellant number 1 ବୁଧିଆ alias ବୁଧିରାମ ମୁର୍ମୁ ସେଠି ଆମେ ଲେଖିଛୁ ଯେ ତାଙ୍କର contention raise ହେଲା appellant number 2 is similarly situated ଏବଂ ଦେଖିଲୁ ସେ ହଉଛନ୍ତି 10 ବର୍ଷ ତ यार जदि 2015 रे रिजेक्ट हला माने सेबेटू तो हेगलानी 9 वर्ष केते मास हेगला ता पूर्वरु से पुनी थिबो.
My lord, he was in interim bail for 2 weeks. In miscase number 162 of 2015 by the order dated 6/2/2015. I have mentioned it.
Just a minute. 6/2/2015.
Yes, madam.
Interim bail for a period of 2 months.
2 weeks.
2 weeks.
2 weeks, madam.
Yes.
Basanta Marandi.
Basant Marandi.
Basant Marandi. Present appellant number 3.
Oh, it was allowed for 2 weeks. Here
Bappa
to attend funeral.
Right time रे surrender कला कि न कला custody certificate टा नहीं.
Yes.
No, it a custody certificate. ये land council for the appellants file surrender certificate of appellants Kataram Prusti and Basanta Marandi.
For sure,
Question this time. Therefore, you do not find any reason to grant bail to these appellants. It is rejected.
So, ଲେଖିଛନ୍ତି ତାର paragraph number 12 ରେ custody ହଉଛି 11/12/2011 ଏବଂ ଲେଖିଛନ୍ତି ଯୋଉ 2 ମାସ 2 ସପ୍ତାହ ପାଇଁ ବେଲ୍ ଯାଇଥିଲେ ସେଟା ମଧ୍ୟ ମେନସନ କରିଛନ୍ତି paragraph 13 ରେ interim application ଏବଂ କେବେ ରିଜେକ୍ଟ ହେଲା ସେଇଟାକୁ ଲେଖିଛନ୍ତି 1, 2 ଅନ୍ୟମାନେ ତ ବେଲରେ ଯାଇଛନ୍ତି
ଅନ୍ୟମାନେ ଯାଇଥିଲେ ସିମିଲାର ଫୁଟିଂ
are the learned counsel for the petitioner learned counsel for the state. The learned counsel for the is an application for therefore appellant number 3. Learned counsel for the petitioner submitted that the petitioner is in judicial custody in connection with this case since 11/12/2011, and his earlier bail application in miss case number so and so was rejected by the order dated 24/3/2015. Prior to that, I would like to that he was granted an interim bail for a period of 2 weeks, as per order dated 6/2/2015. He further submits that the petitioner has remained in custody for more than 13 for about 13 years for them, and other co-accused persons have already been granted bail, and paper book has not been prepared. Therefore, there is no chance of early hearing of the appeal, and the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the release of the similarly situated co-accused persons on bail, and absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail allowed.
Item 5.
Yes, Mrs. Patnaik.
This is the application for premature release of the appellant on the basis of the.
Please adjust the mic.
This is an application for premature release of the appellant with a life convict on the basis of the decision of Honorable Apex Court, which have annexed under Annexure 1. And also along with that, the prisoner's petition, who has been praying to consider his case, the period already undergone in sentence.
No, whether the government has appropriate government has considered your case. It is to be routed through the jail authority has whether they have sent it or not.
Yes, they have sent it.
So what is the result?
Result, I don't know.
That is to be pursued in the government, appropriate government.
You should have filed if your application is there and it has not been acted upon, you should have filed a writ petition so that appropriate direction could have been issued to see that it is expeditiously. Why have you filed in this criminal appeal for premature release?
As per the decision of this,
It's all right. They have let down the order.
Yes.
Supreme Court has let down a general rule, but since you have already applied for, how can we do not know that what is the and if they are not acting upon which
Yes.
they are supposed to do, and the time limit has also been framed that they should, and the procedure has also been laid down. That
Yes.
how such an application is to be considered, what data is to be obtained,
Yes.
all those things. And what is the period minimum requirement should he stay so that he can get the benefit? Of course, there is no bar for premature release during the pendency of the criminal appeal. There is no bar.
Yes.
So you can, that can be, but if you are saying that it is pending for, then the copy of the application should also be with you. And you must also be aware that when your application was forwarded to the appropriate government for consideration. So if there is delay, so you can file a, why have you filed appropriate order for here?
You can also move through
prisoner-
Secretary State Legal Services Authority.
Yes. Prisoner's petition is Annexure 2 through direct. I have been instructed by the legal aid that to file the appropriate application before this honorable court for premature release. On the basis of that,
state legal services.
it is of
What
the
is your application? We do not know anything.
Annexure 2, page 12.
Annexure 2 रे कौन है?
Prisoner person.
That's a format, Mr. ନାୟକ କୋଉ କେସ୍ ରେ ଇଏ ହବ କେତେ ରହିଲାଣି ତା ଦେହରେ ତା ଦେହରେ ଗୋଟେ ଯିବ ସେ ତାର କଣ୍ଡକ୍ଟ ସାର୍ଟିଫିକେଟ ଇଏ ସେ ଗୋଟେ ତାର ଗୋଟେ ଫର୍ମାଟ ଅଛି ସ୍ୱତନ୍ତ୍ର ଯୋଉମାନେ ପ୍ରି ମ୍ୟାଚୁର ରିଲିଜ ହବେ ତା ସବୁ ସେ ଫର୍ମାଟ ରେ ହିଁ ଯାଏ ନଟ୍ ଦ୍ୟାଟ ଏମିତି ଗୋଟେ ଆପଣ ମତେ ଆଜ୍ଞା ଆଗକୁ ଛାଡି ଦିଅନ୍ତୁ ଗୋଟେ ଆପ୍ଲିକେସନ ଦେଇଦେଲେ ସେମାନେ ଆଣ୍ଡ ଦ୍ୟାଟ ଇଜ ଟୁ ବି ଦେयर ଇଜ ଏ କାହା ପାଖରେ ପ୍ଲେସ୍ ହବ କିଏ କନସିଡର କରିବ ସବୁ ଡିଟେଲ୍ସ ରହିଛି ଆପଣଙ୍କର ସ୍କିମ ରେ ହିଁ ଅଛି କେତେ ବର୍ଷ ହେଲେ ଯାଇକି ତାକୁ କନସିଡର ହେଇପାରିବ ଏସବୁ ଡିଟେଲ ପ୍ରୋସିଡ୍ୟୁର ଲେଟ୍ ଡାଉନ୍ ଏମିତି ଗୋଟେ ଖାଲି ପ୍ଲେନ ପେପର ରେ ଡିଏଲଏସ୍ ଲେଖିଦେଲା ସେଠିକି ଆପଣ ଗୋଟେ ଫାଇଲ କରିଦେଲେ ଆପ୍ରୋପ୍ରିଏଟ ଅର୍ଡର କେମିତି ହବ ତାକୁ
paper week also ready, my lord. Paper
paperwork ready
after vacation date may fix so that
for hearing.
He has filed that this is come for orders for that consideration of that.
Yes.
If you are ready with the case, then we can take it up. Paper book is also ready. Let me know. The matter will be added to the hearing list in the second week of January 2025. Yes.
The miss case may be withdrawn.
This IA number so appropriate order, Mr. Patnaik Land Council takes permission to withdraw this application. Disposal of are done. Sterilization of fine allowed.
The paper book may kindly be supplied so that hearing can be.
Fine दिया कौन?
ना.
अपन पाइशन paper book.
वो पाकर.
अच्छा. Since Mrs. Patnaik has already received a copy of the paper book, let a copy of the paper book will also be supplied to the Land Council for this state. आज भी देखें तो हम देखें signature मिल जाए. Yes.
After vacation, maybe.
Yes, second week of January 2025.
Yes.
Hello.
Earlier also bail was rejected by this honorable. Bail was also rejected.
No, you have not filed any application for bail here.
No.
You have filed for the.
This is another. Yes.
That is a total different procedure.
Yes, yes.
Right.
Item 6.
May I present? My interim bail application flag ASC lords. If he is suffering from cancer, now undergoing treatment as an indoor patient at Acharya Harrier Cancer Institute, Kotak.
Is it coming for the first time or earlier order was passed to obtain instruction?
No, it's first time, lords.
So you have received the copy of the interim application?
Yes, that is in supplied, lords.
IN number
AN 12/2024.
of 24.
10/12/2025. If you also direct, I will file in course of dial supply another copy.
Right. IN number 3203 of 2024. This is an application for interim bail filed by the appellant.
Only appellant number 1, Mrityunjay, lords. There are two appellants.
Number 1. Appellant number 1, Mrityunjay Patra.
Yes.
On the ground that his wife is suffering from cancer and she is continuing her treatment as an indoor patient before in Acharya Harihar Postgraduate Institute of Cancer. Medical documents in support of such averment has been annexed to the interim application. Land Council, Ajidebe, Land Council, let the Land Council for the appellant supply the copy of the interim application to the Land Council for the state in course of the day, and instruction on this one should be obtained in
short date because serious condition, lords. Serious condition, short date, lords.
Next week, indoor patient हिसाब आचार्य हरिहर रोचंती कटक आसो सोमवार दिन आसो
Oblige, lords.
Item 7.
Please, Your Lordship. Lordship, the appellant is in custody since 4/4/2010. He was released twice on interim bail, one in 2020 on occasion of his father's death,
and other in 2024 May. Your Lordship, we don't have instructions regarding the total amount of period undergone in custody, whether he was released during the COVID period or not.
What is the total period you have remained in custody?
Your Lordship, according to my information, it's 14 years and 8 months odd. He has been in custody since.
Not got the custody certificate with you.
No, Your Lordship, at present we don't have it.
So get it that custody certificate. In which jail he is then?
Your Lordship, he was arrested in the year 2010, 4th April 2010.
ଆପଣ କ୍ଲାଏଣ୍ଟ ବର୍ତ୍ତମାନ କୋଉ ଜେଲରେ ଅଛି କୁହନ୍ତୁ, ସେ ମଗେଇଦେବେ ସୁବିଧା ହବ। ଖୋଜୁଥିବେ କଣ ସିଏ, କାରଣ ତାଙ୍କୁ ସବୁ ବିଭିନ୍ନ ଗୋଟେ ଜେଲରୁ ଆଉ ଗୋଟେ ଜେଲକୁ ପଠାନ୍ତି ସବୁ ଏମିତି। ତ ଗୋଟେ ଜେଲରେ ତ ରହୁନାହାନ୍ତି, ଆପଣ କ୍ଲାଏଣ୍ଟ କୋଉଠି ଅଛି କହିଲେ ସେ ସେଇଠି ମଗେଇଦେବେ।
Lordship, I'll
ଜାଣିନାହାନ୍ତି
no, Your Lordship.
ବୁଝିକିନି କୁହନ୍ତୁ, କାରଣ ଏଇ ଯୋଉ ଓକାଲତନାମା ଯେତେବେଳେ ଦିଆ ହେଇଥିଲା ସେତେବେଳେ ଆପଣ ଯୋଉ କେସ୍ ଫାଇଲ କରିଥିଲେ 2014 ମସିହାରେ, ସେତେବେଳେ ଖୋର୍ଦ୍ଧା ସବ୍ ଜେଲ ରେ ଥିଲେ ବୋଲି ଅଛି ସିଲ ରୁ। ବର୍ତ୍ତମାନ କୋଉଠି ଅଛନ୍ତି କଣ ଅଛନ୍ତି ଆପଣ ଖୋର୍ଦ୍ଧାରେ ଦେଖନ୍ତୁ, ଯଦି ଥିବ ତ ଭଲ କଥା। The Learning Council for the state has produced the report from the IIC Banpur police station dated 24/9/2024, which indicates that the petitioner has not misutilized his liberty while on interim bail and nothing adverse has been reported against him. The report is taken on record. IA number so answer is an application for bail. Then counsel for the petitioner submits that she has instruction. What is your good name?
Anvesha Mishra.
Give it in writing. So answer submit that she has instruction that the petitioner is in judicial custody for about 14 years. Let the Learning Council for the state obtain the custody certificate of the petitioner out of this matter January 1st week, 2nd week of the no.
He is in interim bail on number of times, no?
Twice, Your Lordship.
Item 8.
Yes, Ms. Mahapatra, it is your matter. Yes. ଆପଣଙ୍କର ନୁହେଁ ବ୍ରିଫ୍ ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛି ବ୍ରିଫ୍ ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛି କି ଆପଣ ନାଁ ଲେଖାଇଛି ଆପଣ କହୁଛନ୍ତି
Here, my lord, last occasion, your lordship has directed the Learning Council for the state to obtain instruction
on what?
regarding custody certificate, my lord. Here, my lord, there are two appellants. Out of them, appellant number 2 was dead. Are died.
କଣ ହେଲା ଆପଣଙ୍କର? ଦିଟା ଜିନିଷ, ଗୋଟେ ହଉଛି ସେ ଆବେଟ୍ କରି ମାସେ ହେଇଗଲାଣି ନା, ସେ ମଲାଣି କି ନାଇଁ ଏତିକି ବି ଜାଣି ପାରୁନାହାନ୍ତି ଆପଣ। ସେ IIC ରିପୋର୍ଟଟା ମଗେଇବେ IIC December.
Date of appellant date. In the 9/11, we have communicated or not this right? Along with public certificate on 3 and 5.
ଆପଣ ଏଗୁଡ଼ା ଯୋଉ ଟାଇମ୍ ଟୁ ଟାଇମ୍ ଯୋଉ ଆଡଜନ ହଉଛି କେତେ ଥର ଷ୍ଟେଟ ର ଇନଷ୍ଟାନ୍ସ ରେ
Also intimated of
ଇଏ ରେସ୍ପନ୍ସ କରୁନି ତା ଏଗେନଷ୍ଟ ରେ କୁହନ୍ତୁ ଆମେ we are there here. Don't express your helplessness that and hearing officials should not be fair for this because unless the matter ଆସୁଛି ବଢୁଛି ସେମାନେ ଆସୁଛନ୍ତି ଆଟେଣ୍ଡ କରୁଛନ୍ତି କଣ ଦରକାର ଏଟା ବାରମ୍ବାର ଲିଖତ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ପଠେଇଲେ ଗୋଟେ ମାସ ଆମେ ସମୟ ଦେଲୁଣି ଆଡଜନ କରନ୍ତୁ ସେଇ 23 ତାରିଖ ଆସୁ 23
Item 10.
I filed an IA for bail of appellant number 2, my lord, on the ground of illness, my lord.
JCRL 25 of 2018.
My lord, your lordship called for the report, my lord.
ଅଣତିରିଶ 10 ରେ ପ୍ରଥମ ଅର୍ଡର ହେଇଥିଲା ତାପରେ ପୁଣି ଆଉ ଗୋଟେ ଅର୍ଡର ପାସ୍ ହେଲା 18/11 ରେ ଆଉ ହି ସଫରିଂ ଫ୍ରମ ଭେରିୟସ୍ ଏଲିମେଣ୍ଟ 29/10 ରେ ଆମେ ଲେଖିଥିଲୁ both the legs have been paralyzed, is unable to attend the call of nature without the help of others, and treatment is provided to so and so medical documents. So ଦେଢ ମାସ ଉପରେ ହେଇଗଲା
JCRL 25.
JCRL 25 of 2018.
Control.
And the treatment papers are been କେବେ ଗାଡି ନାଇଁ ତାର ଦିଟା ଯାକ ଲେଗ ପାରାଲାଇଜ ହେଇଯାଇଛି even if he is unable to attend the call of nature ମାନେ ତାକୁ ଟେକି ଟେକି ନଉଛନ୍ତି
condition report of convict Pandurun died 62 years. By letter such and such of the advocate general of this quarter, the convict Pandurun is suffering from XTNC severe things point suffering. Now he is under medication for KD. As per advice of the nephrologist, Dinsar, his present condition is stable.
କେତେ ବର୍ଷ ହେଲାଣି ରହିଲାଣି
Custody since 25 to 2016. Earlier, he was granted interim bail for a period of 3 months, my lord.
କେବେ
On 3/12/2020.
3/12/2020.
My lord. Surrender in the time.
or the learned counsel.
ଏଇଟା
Interim bail ଯାଉ ରହିଲା ଯାଇଥିଲା ଥରେ 3 ମାସ ପାଇଁ।
There is no specific overtake by the present appellant, my lord. Other accused persons are there, my lord. Old person.
70 କେତେ କଣ କହୁଥିଲା?
କେତେ ତାର ବୟସ? What is his name?
Pandru Munda.
Pandru Munda ଟା judgment କୁ ପଠାବ। Judgment ହେଲା
70 କେତେ କୋଉଠି ଲେଖା ହେଇଥିଲା କୋଉଠି ସେଟା ଲେଖା ହେଲା?
67 ତାର ହେଇଥିବ। 67
IA number one, so is an application for bail of appellant number 2. कौन appellant number 2 रो ना? अपील मेमो टा बाहर करो।
Appellant number 2. Now it is
Pandru Munda. The land counsel for the petitioner submits that trial court report of working.
first up, जो जेल क्रिमिनल होते हैं पंडू और सोनू दी जाओ सीधा। सोनू मुंडा पंडू मुंडा दी जाओ।
नहीं 10 नंबर जेसीआर ले 25 of 2008 में पांडु मुंडा अच्छी तो बेल दिया इतला देर 3 मास में पांडु मुंडा was taken into judicial custody on 26/2/2016. The bail trial court रे bail नथिला।
No.
Produced in custody. Judgment भी produced in custody. And he was never released on bail during trial. However, during pendency of the appeal को पड़ा था। He was granted interim bail. केब्बे दिया इतला हो?
On 3/12/2020 में
3/12.
मतलब
हाँ मुझे was granted interim bail for a period of 3 months. By order dated 3/12/2020 in IN number 64 of 2020. ठीक था? And after completion of interim bail period is surrender. The land counsel for the petitioner has submitted the medical documents and contended that the petitioner health condition is not good and she is suffering from various ailments and his both legs have been paralyzed and he is unable to attend the call of nature. He is unable to attend the call of nature without the help of others, and is also under the treatment at Vimsa, Burla, Sambalpur and Raurkela Government Hospital. Medical documents have been annexed to the interim application. The land counsel for the state was asked to obtain instruction on the interim application. Land counsel for the state submitted that instruction has been received that the petitioner was hospitalized and now his condition is stable.
periodically health checkup चली सी।
हाँ ठीक। ठीक है सर रिपोर्ट दे दूँ he filed the report which is taken on record considering the submission made by the land counsel for the respective parties, the period of detention of the petitioner in judicial custody and the conduct of the petitioner in complying with the earlier interim bail order. The copy का xerox कर रख दो आपको. We are inclined to release the petitioner on interim bail for a period of 3 months. है ना? এটা হচ্ছে কি পান্ডু মুন্ডা তার হলো জনকর হ্যাঁ appellant number 2 পান্ডু মুন্ডা.
Item 11.
May pleaders.
ଗୋଟେ order କରିବ ଯେ he has to produce the surrender certificate.
To call for the custody certificate.
Your submission was that he is in custody for more
My
than 10 years.
Yes, yes. Indeed.
ଲେଖିଛନ୍ତି କୋଉ ଜେଲରେ ରହୁଛି?
Barampur.
10/12 ପଠେଇଥିଲେ 23 କୁ ରଖୁଛି ଦେଖନ୍ତୁ. Land Council for the state submits that instruction has already been sent to the concerned jail superintendent for sending the custody certificate of the appellant, but the instruction is awaited. The matter may be taken up next week. 23/12/2024. Yes.
Item 13.
Thank you, Your Honor. Madam, the application for 15 days interim bail, madam. And the appellant petitioner is a retired army colonel, madam. And he is the pension holder. And the life certificate for spouse is required to be produced to pension holder at the end of every year, madam.
Achha.
And through the welfare officer or the petitioner appellant produce the life certificate to the SBI main branch, but the life certificate is returned without connection, my lord. And the physical appearance is necessary, my lord, for sports system of pension holder, my lord.
My lord, the regular bail as well as the interim bail application of the petitioner was rejected on 28/10/2024.
No, he is on a particular.
My lord. Your lordship may kindly direct the jail authority to
ensure the
to produce the petitioner before the appropriate authority for ensuring the.
Who is that appropriate authority before whom he is to? Yes.
My lord, the sports generate sports is the 120 battalion of Bhubaneswar. The Ministry of Defense
120 battalion को नेले सेमान से कर दे
120 battalion भितरे sports ऑफिस अछि पेंशन होल्डर मानकर आर्मी मान होल्डर मानकर पेंशन डा थ्रो स्पोर्ट्स रे पोर्टल रे
सेटिंग नहीं प्रोड्यूस कला अपन काम होई जो तो
आगे आगे मान लो
देखो IN number so and so. This is an application for interim bail. इकोन डॉक्टर सोमनाथ पंडा परिणाम नहीं कौन
सी डॉक्टरेट करिछथि किंतु ता वाइफ की रिटायर्ड कर्नल वाइफ की काटी की भीतर रख देथिल
एलिगेशन आइलो
all right see on the ground that who ground mention करछन्ति
annexer B/1 ताकर
annexer B1
petitioner is a pension holder and as per the provision life certificate for spouse all capital is required to be produced to the by the pension holder at the end of every year. Otherwise the pension of the pension holder remain blocked. In case of failure. It is submitted by the Land Council for the petitioner that the petitioner produced his SBI certificate through jail authority duly signed by the prison welfare officer Circle Jail Chaudhar on 13/11/2024, which was received by Ministry of Defense on 18/11/2023. But the same has been written on action along with the connected documents. And in the written letter, it has been mentioned that the identification certificate / life certificate for spouse migrated defense pensioner has to be submitted in the spouse portal either digitally or manually. And there is no provision to upload manual life certificate other than the system bracket spouse generated manual life certificate. The Land Council for the petitioner submitted that the appearance of the petitioner before the authority under the spouse system is very much necessary for continuance of his pension, which has stopped with effect from November 2023. The Learned Counsel for the petitioner has annexed the document of so and so as annexure 1.
B by 1.
B by 1. 1 B by 1. The Land Council for the state, on the other hand, submitted that the jail authority can do the needful in producing the petitioner before the concerned authority in terms of this annexure B by 1. In view of such submission, while not inclining to release the petitioner on bail, we direct the
Superintendent Circle Jail Chaudhar.
Superintendent Circle Jail Chaudhar to make necessary arrangement so that the petitioner can be produced before the authority under the SPOS system. Hello?
The 120 battalion.
120 battalion ଭିତରେ ଅଛି ପ୍ରିମାଇସ୍ ଭିତରେ ଅଛି ସ୍ପଟ ସିଷ୍ଟମ
ସେ ଯୋଉଠି ଅଛି ସେ ପ୍ରଡ୍ୟୁସ କରିବେ ଆପଣ
ପ୍ରିମାଇସ୍ ଭିତରେ ସେଟା ଅଛି
ସେ ଜାଣିନଥିବେ ଆପଣଙ୍କର
ନେବେ ତ ସେ
ତ ନେବେ ସେଠି ପ୍ରଡ୍ୟୁସ କରିବେ ଏତେ ଡିଟେଲ କଣ ଲେଖିବା within 2 weeks ଭିତରେ ତାଙ୍କୁ ପ୍ରଡ୍ୟୁସ କରିବେ within a period of 2 weeks.
Petition will be directed to file the certified copy before the Chaudhar.
The authority shall act upon the production of certified copy of this order before disposed of, IA is disposed of.
ଯଦି 2-3 times ଯିବାକୁ ପଡିବ କଣ ଦରକାର ପଡିବ
ସେଟା ଲେଖାଇଦେବ number of times.
Agent when required, agent when will produce so and so and will further produce if agent when required. Hello?
Item 15.
15 minutes. Paper book has not been spared. The petitioner is in custody since 15/2/2010.
Where is your custody certificate? Mr. Mishra, have you got the custody certificate?
No, madam.
Now the instruction has passed, even if the prisoner wants also, that can be
That
given.
can
It's not that
SCRL, my lord, let me.
ठीक ଅଛି କିନ୍ତୁ the IA number so also there is an application for bail. The Learned Counsel for the petitioner submit that he has instruction that the petitioner is in judicial custody since
17/2/2010.
17/2/2010. Let the Learned Counsel for the state obtain instruction produce this custody certificate of the petition. Sundargarh district jail ଅଛି ହେଲା
After adjustment.
after
Item 16.
Here the appeal bail, my lord. Date of occurrence, my lord, 18/10/2015, my lord. And date of FIR, my lord, 19/10/2014. This is, my lord, Renga Singh, and another one is Basu Singh, my lord.
your bail application was rejected on 26/24.
My lord, this is a second round bail application.
So why have you come again? We have rejected giving the details that it's a case of double murder. The nature of circumstantial evidence available on record, and that the petitioner he has remained in custody for only 1 year and few months. if the pre-detention period and post-trial detention is taken into account. So, 26 ମାନେ ଆଉ ତା ଭିତରେ ଜାଣ 6 ମାସ ବି ଯାଇନି ଆପଣ ପୁଣି ଗୋଟେ ବେଲ୍ ଆପ୍ଲିକେସନ ଦେଇଦେବେ।
Impung judgment there is a some lacuna are there.
Huh?
In impung judgment paragraph 19 there is a circumstance entire cases based on the circumstances.
ସେଟାକୁ ଆମେ ପୁରା କନସିଡର କରି ମେରିଟ ରେ ରିଜେକ୍ଟ କରିସାରିଲୁଣି ବର୍ତ୍ତମାନ କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ଯେ ଆପଣ ମେରିଟ ରେ ଆଉ ପାଇବାର ନାହିଁ ଆପଣଙ୍କର ପିରିୟଡ ଅଫ ଡିଟେନସନ ଉପରେ ବର୍ତ୍ତମାନ କଥା ରହୁଛି ତ ଆମେ ସେତେବେଳେ ମଧ୍ୟ ତାକୁ କନସିଡର କଲୁ ଏବଂ ଦେଖିଲୁ ଯେ ଜମା ଆପଣ ବର୍ଷେ 6 ମାସ ରହିଛନ୍ତି ଟୋଟାଲ ପିରିୟଡ ସେଥିପାଇଁ ରିଜେକ୍ଟ କଲୁ ଆପଣ ପୁଣି
three daughters are there ଯୋଉମାନେ କି ମ୍ୟାରେଜ ଏଜ ହେଇଗଲାଣି
ହଁ
three daughters are present in the
ବାହାଘର ଯଦି ଅଛି ହେଇଗଲାଣି କାର୍ଡ ଦିଅନ୍ତୁ ଆମେ କନସିଡର କରିବୁ କିଛି ନ ଦେଇ ସେମିତି ଖାଲି ଏଇଟା ଫାଇଲ କଲେ କଣ ହବ ଆପଣ ତ ସେ ଝିଅଙ୍କର ବାହାଘର ଠିକ ହେଇଗଲାଣି ନା କଣ
ଠିକ ହେଇନି ଠିକ
ହବ ହଉ ହେଲେ ହବ ଆପଣ ଫାଇଲ କରିବେ IN number so and so this is an application for bail it appears that I had order dated 26/2024 in IN number so and so we taking into account that it is a case of double murder and the nature of circumstantial evidence available on record and that the fact that the petitioner had remained in custody for only 1 year and few months if the pre-detention period and post-trial period is taken into account, we rejected the bail application. Stop. We find no change in the circumstances.
in this case paper book ready ଅଛି ତ hearing ପାଇଁ
we are not inclined to so and so. କଣ ହେଇଛି
ପେପର ବୁକ୍ ଟା ମେଲ ରେଡି ଅଛି ହିୟରିଂ ପାଇଁ
2023 ମସିହାର କେମିତି ଆପଣ ମାନେ କେତେ ବର୍ଷ ହେଲାଣି ଲୋକ ସବୁ ରହୁଛନ୍ତି ତାଙ୍କର କେସ୍ ଆପଣ ଜମା ରହିଛନ୍ତି 1.5 ବର୍ଷ 2023 ମସିହାର ଅପିଲ ଆମେ ଶୁଣାଣି କରିବୁ ଆଉ ପୁରୁଣା କେସ୍ ଗୁଡା କଣ କରାଯିବ
This is a matter of the year 2022.
22
No, incident.
2022
Incident is of 22.
Incident mele 2014
14 से ଆସିଛି abscond କରିକି ତାପରେ
ନା ବେଲ ଏଣ୍ଟାର ବେଲ ରେ ଥିଲା ଏଣ୍ଟାର ଟ୍ରାଏଲ ମାନେ ତାପରେ ଆଫ୍ଟର ଜଜମେଣ୍ଟ
ତାପରେ ନେକ୍ସଟ
Item 17.
I have been engaged by the court. Your Lordship order dated 19/11/2024. Now, my lord, here लिखा है engagement of counsel Sushant Samantray by the prisoner petition. So, your Lordship.
Where is Mr. Samantray?
I have already received the paper book also.
No, ठीक ଅଛି ସେ ସୁଶାନ୍ତ ସାମନ୍ତରାୟ ପାଇଁ ସେ ଦେଲେ ଗୋଟେ
11/24 ରେ ଆସିଛି ନା ଆମେ 19 ରେ ଦେଇଥିଲୁ
ହଁ ଯେ ସୁଶାନ୍ତ ସାମନ୍ତରାୟ କିଏ କଣ କିଛି ନାହିଁ ସେ ବି ଫାଇଲ କରିନାହାନ୍ତି ତ କିଛି
ସେ ଆସିଲେନି ବୋଲି ଆମେ ଆପଣଙ୍କୁ ଦେଇଥିଲୁ 10 ରେ ତାଙ୍କ ଫେଭରରେ ଗୋଟେ ଆସିଥିଲା ପ୍ରିଜନର ପିଟିସନ ସେ ଡିଡ୍ ନଟ୍ ଟର୍ନ ଅପ୍ ଏବେ ପୁଣି ଗୋଟେ ଆସିଲା
ଇଏ ଚୌଦ୍ୱାର ଜେଲର ଏ ଲୋକଟାକୁ ତାକୁ କାଲି ଇଏ କରନ୍ତୁ କାରଣ ଆର କିଛି ଡିଟେଲ ନାହିଁ ତାର ପର୍ସନାଲ ଆପିୟରାନ୍ସ ସବୁ କରାନ୍ତୁ ମାନେ ଭର୍ଚୁଆଲ ମୋଡରେ ହେଲା ସେ ସୁଶାନ୍ତ ସାମନ୍ତରାୟ କାହାକୁ ସେ କହୁଛି ଦବା ପାଇଁ ତାଙ୍କର ଯଦି ସେ ଡିଟେଲ ନ ଦବ ମାନେ ତା ଫୋନ ନମ୍ବର କମ ସେ କମ ଆଟଲିଷ୍ଟ କାରଣ ଭି ନାମା ସେ ଫାଇଲ କଲେନି ତାଙ୍କର ଓକାଲାତନାମା ନାହିଁ ଏବଂ ତାଙ୍କ ନମ୍ବର ବି ନାହିଁ ତେଣୁ ଜଣା ପଡୁନି ସେ କାହାକୁ ଦବାକୁ ଚାହୁଁଛି ସୁଶାନ୍ତ ସାମନ୍ତରାୟ କିଏ ତେଣୁ
Lordship, Sushant, that is Sushant Kumar Samantray.
ହଁ କିଏ
से ମୋ ଭାଇ हो Lordship.
then why are you not filing your V nama?
Lord, I have to ask him, Lordship.
No, are you sure that he
Yes,
is
Your Lordship.
referring to
Yes, Your Lordship.
there is only one Sushant Samantrai?
Yes, Your Lordship.
So earlier also on in the month of October, a prisoner petition was there.
And nobody appeared. That is why we engaged Mrs. Das as the counsel.
Because it is jail criminal appeal, we can't wait.
Your Lordship, I'll inform him.
And this petition is coming from Cuttack jail.
Yes,
So
Your
it would not be that difficult to obtain the VNAMA and file it. ଏବେ ଯୋଉ prisoners petition ଟା ଆଇଛି flag B ରେ ଦେଖନ୍ତୁ,
Yes, Your Lordship.
that is from Cuttack Chowdhuar jail. So,
Yes, Your Lordship. A and B.
like you file it, otherwise we'll reject it, and she will continue to be the counsel.
Yes, Your Lordship. I'll inform him.
A mention is made on behalf of Mr. Sushant Samantrai that the matter may be taken up next week so that necessary steps for filing VNAMA will be made. It is this matter on 23rd of December 2024.
And last order is a very detailed order of your lordship.
Give him a copy. We'll take up this matter after Puja holiday.
May I pray, my lords, before that, if it is possible?
No,
Because almost a decade I have lost.
It's all right, Mr. We'll take up in the first week, but it's not possible. Dita the din of court of court level. You have detailed hearing the turn.
Then, my lords, I have a small prayer.
Yes.
I have never, though there is a IA, I never pressed it because there was no requirement. Now the court is pressing hard for charge, and it's fixed to 26th. Lordship may grant me interim order.
No, we do not know what is there. So,
Lordship may say that if a petition is filed, favorably considered for adjournment.
No, this is a very old matter. So
Yes, your lordship remember.
Once it is decided, Mr., that will go. So let the charge be framed. There is no problem.
Ultimately, that
if
will
it
go.
is decided. So
Because they are taking time. I've never prayed for.
It is in pursuance of the order dated 13/11/2024. The Learned Council for the state has filed an affidavit.
It's by the Deputy Secretary, your lordship directed Home Secretary.
Opposite party number 1. The affidavit is taken on record. Copy of the affidavit has been served on the Learned Council for the petitioner as well as the Learned Council for the vigilance. And both of them 6 times to the same put of this matter, January 25.
It's not by the secretary, lords. Your lordship directed the secretary to file an affidavit. Your lordship directed the secretary to file an affidavit because earlier a deputy secretary filed an affidavit that your lordship rejected, that it was baseless, then directed the secretary himself to file an affidavit.
Somendra Patra, deputy secretary, had filed it.
But the order was the secretary because that was rejected. They filed it earlier. And your lordship found that it's irrelevant and defective. It's there in your lordship's order.
Yes, let the state government, that is secretary in Home Department, Government of Odisha to file fresh affidavit.
Yes, before that, Your Lordship rejected that affidavit filed by them.
Deputy Secretary had filed it.
Yes, and again Deputy Secretary.
Acha.
Okay, we'll see that. Yes, next.
Item 25.
Results.
Council of these and so on. Yes.
My lord, I have filed an application for bail, my lord. Convicted under section 376 2I.
heading रे कहीं हैसला admission heading रे अपन admit है नहीं की No, admit है नहीं is it a case under 302
No, my lord, 376 and 6 books.
and why it has come before the division bench? Life imprisonment.
Life imprisonment.
Oh, then it's all right. Hard admit call for the.
My lord, the paperwork has already been prepared, my lord.
Huh?
Paperwork has already been prepared, my lord. I see. हाँ.
अच्छा. Hard admit कर लेता हूँ. पेपर बुक रेडी चे अपन आर्गुमेंट करो चलो ये परे जनवरी से हमें ऐड कर दो छु हियरिंग लिस्ट है ना
2000
लाई ओवर था दे दी देरी हो तारे देखियो
2013
नंबर 100 में लाई ओवर मैटर बी एडेड टू दी हियरिंग लिस्ट अपन कॉपी पाई चे पेपर बुक नो since the land council for the appellants also the land council for the states have already received the copy of the paper book. Matter be added to the hearing list in the January 2025 and interim applications live.
My lord, with permission, my lord, item number 24 on behalf of the Orissa Rural Housing Development, I am for the OP number 2. My presence may kindly.
PRLMP.
My lord, my lord.
कहाँ पे अपन अछन मिस्टर साहू?
My lord, Orissa Rural Housing Development Corporation. My lord has passed on order dated 13/11/2024.
अपन प्रेजेंट नोट करू कहाँ पाई मु लिखियो
ORHDC में
अच्छा लिखि दियंतु एटा उपरटा रहइबो हार्ड मिस्टर टूना साहू जहाँ अछि समस्त ना रहइबो से ऑपोजिट पार्टी नंबर 2
oblige deep.
Item 28.
to argue this matter.
Engaged.
Mr. Tripathi, the case under section 302
and 309, ma'am.
The allegation is that the mother administered poison to her children and also tried to swallow it. And
how many of them had died?
Both the children died, man.
What was the age of the children?
One is 4 years and another is 8 years old.
So what type of evidence is available?
The circumstance, oral dying declaration given before the villages and extrajudicial confession and the PM report.
Oral dying declaration by both the children?
No, by one child. One child.
What was his age at that time?
8 years old.
8 years. Okay.
Her name is Bonolata Mahalik, the deceased.
What she stated that?
She stated that my mother administered the poison to us by giving in a
poison से क्यों जानला?
That is to be seen, my lord.
अच्छा.
And interestingly, the medical report also without viscera, the doctor opined that this is a agrophosphorus. And there was no motive also present in this case. These are the 3 points on which I will have.
No, there is no viscera report.
No, ma'am. Viscera report was preserved, but that SFSL report was not brought.
Achha, not produced. It
No.
was not marked as an exhibit.
No, ma'am.
The doctor is PW?
9. PW9 the PM report and PW10 is the doctor who referred them to the main hospital, Bhadrak Hospital University from Chandwad.
So, what is this particular poison, organophosphorus poison? Can it not be detected without this?
Smell was there.
Because you have brought clarification in the cross-examination how he could able to detect it. In the chief examination, he has stated that it is characteristics of smell, so and so is, and in the it is in a detailed manner it has been mentioned that stomach also contains black granular poison smelling typical of so and so, or intestine so and so. This is so. Have you studied whether the organophosphorus poison is such a thing which cannot even ये जो आपण जो दाना खा कौन की दानादार जो विष खाते सेଗୁଡାକ माने जना पड़ी जीवो आपनकर ये apart from the symptoms सी जहा देखुची ता सहित सी देखुची जे आपनकर ए जिंस गुड़ाक अनडाइजेस्टेड फूड किछि अछि ता द्वारा ता सहित एगुड़ाक मिसिकिनी रहिछि एवं सेइथुरु से होची स्मेल भी आसुची सेमी डाइजेस्टेड रही ता सहित से जो ब्लैक ग्रानुलर ये गुड़ाक रही से कहते जे सस्पेक्ट
is giving a definite opinion.
But it is the settled principle of my lord, when there is a poisoning death, viscera report is signed qua non, my lord.
No, where there is a doubt.
इसी तो डाउट करूनी इन एडिशन टू दैट आपण माने ये करछन्ती have you got any authority to show that
that is there. I have authority. Supreme Court judge as well as this honorable court judgment.
No, judgment हुए आपनकर you come to the medical science. Medical science रे organophosphorus poison आपनकर मोदी अन्य jurisprudence रे organophosphorus poison टा it is only possible to be detected if it is
Through viscera report.
through viscera report. Otherwise, it cannot be. There are different types of poison. There is a total chapter which is devoted to poisoning. ହେଲା ତା ଦେହରେ ବିଭିନ୍ନ ପ୍ରକାର poison ର ଇଏ ରହୁଛି. Organophosphorus, if I still remember, organophosphorus poison ର ମଧ୍ୟ ରହିଛି. ତାର symptoms କଣ ହବ ଇଏ ରହିବ ଏସବୁ ଜିନିଷ ଅଛି. ତାକୁ ଆପଣ ଦେଖାନ୍ତୁ ଯେ ନା ଏଇଟା it is not possible. But fact remain that he has given some reasons. And most important thing is that you have not challenged that report.
That
Right. So you have not even put a suggestion to the doctor that your report is faulty and nothing is there.
That is there.
So decision is one way. The other is think that whether that is applicable in the facts and circumstances of the case or not. Suppose ଖାଲି ଗୋଟେ ଫେଣ ବାହାରୁଛି ଅମକସ କରୁଛି ସେଇଥିରୁ ଆଉ କିଛି ନ ଦେଖିକିନି ସେ ଗୋଟେ ସ୍ପେସିଫିକ ଗୋଟେ କହିଦେଇଥାନ୍ତା that matter is different. ଯେ ଫେଣ ବାହାରୁଛି ସେ ଗୋଟେ କଣ ପଏଜନ କେସ୍ ବୋଲି କେମିତି ଦେଇଦେଲା because it may be also for other reasons also that can but ଏଠି ସେମିତି କିଛି ନୁହଁ ସେଟା ସେ ଗୋଟେ reasons ଦେଇଛି external appearance ରେ କଣ ଦେଖିଲେ internally କଣ present ଥିଲା କଣ କଣ ସେ ଦେଖିଲା ଆମେ ଦେଖିକିନି ସେ ତାର opinion ଟା ଦେଇଛି which is not challenged at all.
And also find that it might have caused that death. And his lordship, when a person is convicted on 302, there must be a sufficient.
No, have you studied in that light?
No, that part I will.
Organophosphorus poison ର symptoms.
Symptoms.
ଆପଣଙ୍କର jurisprudence ଗୁଡାକ ଦେଖନ୍ତୁ ଦେଖିଲେ ଆପଣ ପାଇପାରିବେ ଇଏ.
ଅଛି ଗୁଡାଏ ଜିନିଷ ଅଛି. Why the child of 8-year-old will be against her mother? Against his mother.
She is not against her mother, my lord. She has given statement, and that was contradiction are there when the oral statement also she had made to the villagers. Different statement is coming up.
Different statement कौन author something.
Yes, जो कोच हम घरे आसिके दौड़ की कहला कि कोच जे नहीं सी दौड़ दे.
No. कହୁची कि जे माने अन्य लोक देइथला एठी मा ना प्रथम थर पय कहिछि. But एगुडा जो minor contradiction, that is no contradiction. गुडा को नहीं माने एई लोक एइया देला बस सेइटारे माने फिक्स्ड रहउची ना नाही सेइटा कंसिस्टेंट रहउची ना नाही बाकी अन्य गुडा को टिके डिटेल्स रे जदी एपट सेपट हेइथिबो that would not go to the root of the कारण छोटो छुआटा
when she knows that my lord the evidence is
there ताकू पॉइजन खाइला परे देला परे से स्टेटमेंट दउची एवं इट इज लाइकली टू जदी मनकर विभिन्न लोक विभिन्न स्टेज रे आसी पचारिचंती तारो मध्य ता कंडीशन मध्य से जे डिटोरिएट करथिबो टाइम टू टाइम तेणु इट इज नॉट दैट गोटे फिक्स्ड रहिथिबो से समस्त पारे
एका प्रकार देखिबो.
Interestingly, that container was also not seized, not found. That was also not there. And one of the evidence is there that she was seeing when the mother was preparing that poison food, and thereafter she swallowed it.
No, poison she kon jani thi
Yes, that is the evidence, man. That is the evidence. That Lord,
Chennai Gaja bhitere na.
that evidence.
You see, माने माँ झियो पुअर रिलेशन.
Yes.
आखी बंद करिकिनी माँ भी यदि आनी कोन देई दबो छुआ खाई दो.
But knowing it fully well that this is poison, probably it is difficult to assert it.
Poison जानिला जेतले रिएक्शन हैला. Poison obviously
No,
जानिला केते बळे जेतले.
I'm reading PW1, your lordship, kind of a glance. Shall I place it, man?
Who is she? Sasmita Malik से कौन हो?
She adjacent house.
अच्छा, neighbor.
I know the accused present in the court. She is my khudi, deceased Barlata and Susan of the accused. I know the informant Narendra Mahadik. Occurrence took place 7 months back in the house of the accused. Husband of the accused were working at Salepur. 3 days after the departure of the husband of the accused, deceased Barlata was crying. The house of the accused is close to my house. I went to the house of the accused and asked her why she is crying. She told me that her mother accused administered Danedar poison in Chennai and gave the same to her and her brother.
Read it.
And then they consumed the same. Thereafter, I asked accused Sukha as to why she gave poison to her children. Accused Sukha told me that she gave poison to her children and that she had consumed poison. I called the villager, narrated the incident to them. The accused and her children were taken to the Chandeli hospital for treatment. The son
What
of
is what is her medical examination report?
that is not there, madam.
No, she was taken to the hospital. Or?
Yes, madam. She was also taken to the hospital. Her medical examination report is not available.
Then the accused କହୁଛି ଚାନ୍ଦବାଲି କୁ ନିଆଗଲା ବୋଲି
ଆଜ୍ଞା
ଆଇଓ କଣ କହୁଛି ସେଟା କଲେକ୍ଟ କରିନି ନା କଣ
ଆଇଓ କହୁଛି ତ
what is the evidence of the IO
PW 11 numbers
ଆଉ ଜଣକୁ hand over କଲେ investigation I handed over the investigation to CA କଣ ଏଟା
ये तो यूडी केस रे करथिले
UD case ଟା ତାପରେ main investigation କିଏ ଗଲା
रे की कर
ସେ AIO କରୁଛି PW
सेम कहता तो
ନାଇଁ
ये नहीं तार एविडेंस नहीं है
I had no charge.
नहीं नहीं एफआईआर कली बोली काई यूडी रिपोर्ट को कन्वर्ट करके कली बोली काई ये तो एफआईआर ही तो ना
ପ୍ରଥମେ ଆଗେ UD case registered ହେଇଛି ଯାହା ଜଣା ପଡୁଛି ବୋଧେ
UD case ଟା register ହେଲା ଭଦ୍ରକରେ ଯେହେତୁ they both died there ତାପରେ FIR ଟା register କରିଛି ଦେଖିଛି
କିଏ କଲା ନାହିଁ ତ
I found so and so DHS I examined or guarded the arrested someone on 5 I received the injury report of Sukha Mahalik କିଏ ଅଛି ପରା ନାଇଁ କଣ ପ୍ରମାଣ ହେଇନି ସେଟା ହଁ ତ injury report ଟା ତ ଅଛି କାଇଁ
କୋଉଠି injury report so far the Bhadrak hospital doctor जो treatment करछन्ती where is that is not there PW 10 has referred them to Bhadrak
and PW 10 is another doctor.
Yes, she has referred them to Bhadrak.
He stated that it's a history of organophosphorus poison brought to bear on examination. It was found semi-conscious. So and so, okay, then referred to DHS. That report has been proved. I informed the OIC that the family consisting of so and so consumed organophosphorus poison at the home, out of which so and so was going to. So this is my report. So it is not only the evidence of the doctor who conducted PM, but the evidence of PW10 also in that respect is there, that he also found it to be a case of organophosphorus poison.
And the Danedar was brought to him by one attendant. Lordship, the second para, history of organophosphorus poison at her home and is brought by her attendant. And interestingly, my lord, there was no motive in this case. Why she administered poison to her children?
It is best known to her why she gave it, how the
In case
other
of circumstantial
No,
evidence,
no,
nothing
or
changed.
otherwise, is she describing the manner for which both the children died? What is her information? She is the mother. Is she giving any other sapo kamudare marigala? Ki taku kiye maridele marigala? Is
She
it her
was
case?
also unconscious because she has also
She had also taken poison. So the question of poisoning is there.
whether administered by
Who has administered? That is the question.
So when the child was in your, both the children were in your company, and you are only there, you are to say, if you have consumed poison, then how your children got the, ସେମାନେ ନିଜେ ନେଲେ କି କଣ ହେଲା କି ତାଙ୍କୁ ମୁଁ ଦେଲି ଏଗୁଡା କହିବା କଥା
Accused
କିଛି
ତ alive ହେଇଗଲା ନା?
That
That means she can describe. ନାଇଁ third ଲୋକ କିଏ ଆସିକି ଦେଇଦେଲେ, she can very much say, such and such person has administered to me too. She can give an exculpatory statement.
Yes.
But some statement could have been there.
ତା ସ୍ୱାମୀ examine ହେଇନି?
No, my lord. Interestingly, he was
ସେ ବି examine ହେଇନି?
No. And in the entire judgment, no motive was proved why she had given.
Circumstances under which both the child said in being minor that dad is holding custody of mother should have advanced that.
ସେ ତାର ଇଏ କଣ accused plea total denial ମୁଁ ଜାଣିନି। ये जो छुआटा जहाँ पर डाइंग डिक्लेरेशन करतला से किए
Finally, PW 1, 2, 3, 5, 6, and 7.
पूरे village हाँ। तापर just before the death is not very
नहीं नहीं हम बंचित
संगे संग से ऐसी कोई चीज दौड़ी की
नहीं नहीं जाइकी भी जंग घरे भी डाकी के भी
हाँ पर तापर deteriorate ହେଇକି ସେ ମରିଛି
somebody
hospital
saying
ଯାଇକି।
that on her crying we reached there and
Right.
somebody said that she had come to my house
Yes,
and
could be।
Son died immediately, but died.
हाँ ସେ ସାନଟା ବୋଲିକି ବୋଧେ ଶୀଘ୍ର ମରିଗଲା।
mother gave poison horse once.
ହଁ ସୁଶାନ୍ତ ତ 4 ବର୍ଷର ଥିଲା ସେ ସାଙ୍ଗେ ସାଙ୍ଗେ ମରିଗଲା। ଏ ଝିଅଟା
and
8 ବର୍ଷ
and
ବେଳକୁ
the accused was
ରେଜିଷ୍ଟ
also
କଲା।
in unconscious state at the time of
जो ये अच्छी ना हमारा मोदी जुरिस्प्रूडेंस देखिए Total, there is a chapter in this new book on organophosphorus. Hello? Organophosphorus compound. तार composition कौन अच्छी तार symptoms कौन आसिबो खाइले ताकू तार fatal dose टा केते हेले कौन हबो ताकू जने जदि ताकू खाई थिबो तार तार post appearance postmortem appearance कौन हबो एवं treatment को प्रकार हेले सेटा ये रहिबो. All these details have been mentioned therein. Respiratory constant mark symptoms such as sundial, fatal dose. Pharmacy. Postmortem stomach contents sometimes lost in intestinal. So you are to go through this one. So you just let us keep against you as we just we are finding that your two children who are the two deceased were in your company, in your house. Your husband has gone somewhere else 3 days back, and on the date of occurrence, it was found that you are having the effect of poison, and so also your both children, out of which one died at the spot, the other perhaps shouted or something that drew the attention of some of the neighbors, and she also disclosed before the neighbors that my mother mixed this thing and gave it to me. So that is a type of thing which is, can say it is dying declaration. Number two, you are unable to discharge your burden of proof. That is when 106 would be also very relevant in this case. How they died when they were in your company. So how they died. Number three, the postmortem finding has not been challenged at all. You are telling that viscera, etc., but the doctor has found these black globules in the inside the food content. So it's a semi-digested food. And coupled with another doctor who has treated you at the beginning, and then all of them report. So both the doctors were of the opinion from the symptoms itself that it was a case of organophosphorus poison. And so far as motive you are concerned, that you are right that in a case of circumstantial evidence, motive assumes a paramount significance. And but suppose that part is best known to the accused and that is not been proved. But if the case is otherwise established in a circumstantial evidence case, and it points to the guilt or the chain is complete. So merely on the failure of the prosecution to prove the motive, even in a circumstantial evidence case, that cannot be a ground for acquittal. So,
I was going through a judgment today morning, my lord. In 2023, Lordship has stated the chain will not complete if the motive is not there.
no, it depends upon case
Yes,
to case.
yes.
It depends upon case to case. So motive is definitely in a, but simultaneously it is not known why the question would be raised that who is to know the motive. It is supposed there is some kind of dissension between the husband and wife. It is not known to the others, and the wife husband might have said something to the wife, and she might have taken it as an exception. That's it.
And
It
a
is
third
not-
person is intervening in the crime. Here there is no third person.
That was also not brought before the
So
court.
that is why I think others might not be ଅନ୍ୟ ଜାଣିବେ କେମିତି ଅନ୍ୟ ଜଣଙ୍କର ଯଦି ସେ ବିଷୟରେ ଜାଣିବାର ସ୍କୋପ ଥିବ ଯୋଉଟା ଆପଣଙ୍କର ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭିତରେ ହେଇଥିବ ଯଦି let us say possibility of knowing by others may be very difficult.
ହେଲେ ତ 106 ଆଉ ଆସିବ
ତେଣୁ ଆପଣଙ୍କର ସେଇଟା ହଉଛି ଏକ୍ସକ୍ଲୁସିଭ ନଲେଜ ଆପଣଙ୍କର ଛୁଆ ଦିଟା ଆପଣଙ୍କ ପାଖରେ ଅଛନ୍ତି ଆପଣ ବିଷ ଖାଉଛନ୍ତି ଆପଣ ଛୁଆ ଦିଟା ମଧ୍ୟ ବିଷ ଖାଇଛନ୍ତି ଏବଂ ଗୋଟେ ମରିଛି ଆଉ ଗୋଟେ ଅନ୍ୟମାନଙ୍କ ଉପରେ ଡାଇଂ ଡିକ୍ଲାରେସନ ଦଉଛି ମୋ ମା ନିଜେ ଖାଇଲା ଏବଂ ଆମମାନଙ୍କୁ ଖୁଆଇଦେଲା ଏଇ ଜିନିଷଟା ଏବଂ ତାପରେ ଯୋଉ ରିଆକ୍ସନ ହବା କଥା ସେ ଜିନିଷ ଗୁଡାକ ରହୁଛି ଦିଟା ଡକ୍ଟର ଆଟଲିଷ୍ଟ apart from the doctor who treated you and the doctor who conducted post-mortem examination. They have stated that it is your main point is that motive not established. Second, I think it is that DCRA report not.
A clear case like this, my lord, and citing the judge.
No, don't go to the case. Don't so.
Similar case.
Last resort to no. You see, a little deviation in the factual aspect would make the difference. In a criminal appeal or even in the trial also, it is always advisable that don't rely on this decision. Factual aspect re ଆପଣ କେତେ ଦୂର ଜଣେ ଜଜ୍ କୁ କନଭିନ୍ସ କରିପାରିବେ that you should take into account. ଏଗୁଡା ହଉଛି ସପ୍ଲିମେଣ୍ଟାରୀ ଜିନିଷ ମାନେ ଡିସିସନ ଫିସନ ହଉଛି ସପ୍ଲିମେଣ୍ଟାରୀ ଜିନିଷ ତେଣୁ ଆପଣ ଯଦି ଫ୍ୟାକ୍ଚୁଆଲ ଆସ୍ପେକ୍ଟ ରେ ଇଏ କଲେ କାରଣ ଗୋଟେ ପଏଣ୍ଟ ରେ ଆପଣ ଗୋଟେ ଡିସିସନ ଦେଖେଇବେ ପାଞ୍ଚଟା ଡିସିସନ ଆଣି ସିଏ ଥୋଇଦେବେ ଯେ ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ ରେ ମୋଟିଭ ପାର୍ଟ ପ୍ରୁଭ ନ ହେଇଥିଲେ ମଧ୍ୟ କନଭିକ୍ସନ ହେଇପାରିବ do you think that that is not there is no decision that is not a criteria that invariably ତାହେଲେ ତ ସବୁ ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ ଯୋଉଥିରେ ମୋଟିଭ ହେଇନଥାନ୍ତା ତା ଦେହରେ ଖଲାସ ହେଇଯାଇଥାନ୍ତା ଗୋଟେ ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ କେସ୍ ରେ ଯଦି that would be the universal principle that wherever the prosecution has failed to prove the motive in a circumstantial evidence case
chain is to be completed.
That you are right. Chain is to be completed. Chain is to be completed. Keeping in view the factual aspect. ଆପଣଙ୍କ ଛୁଆ ଦିଟା ଆପଣ ପାଖରେ ଥିଲେ ନମ୍ବର ୱାନ ଇଏ ଆପଣଙ୍କର ଛୁଆ ଥିଲା ବେଳେ ଘଟଣା ଘଟିଛି ନମ୍ବର ଟୁ ଆପଣ ଖାଇଛନ୍ତି ତାଙ୍କର ରିଆକ୍ସନ ଆସିଛି ଆପଣଙ୍କ ଛୁଆ ଦିଟା ଖାଇଛନ୍ତି ତାଙ୍କର ରିଆକ୍ସନ ଆସିଛି ନମ୍ବର ଥ୍ରୀ ଆପଣଙ୍କର ଛୁଆ ଅନ୍ୟ ପାଖରେ କହୁଛନ୍ତି ଯେ ମୋ ମା ଆମକୁ ଏଇଟା ଦେଲା ନମ୍ବର ଫୋର ତାପରେ ଡକ୍ଟର ପାଖକୁ ଯାଇଛନ୍ତି ଦିଟା ଡକ୍ଟର କହୁଛନ୍ତି ଇଏ ହେଲା ନମ୍ବର ପାଞ୍ଚ ଏଇ ଯୋଉ ଭିତରୁ ଆପଣ ବାହାର କରି ଆସନ୍ତୁ ଯେ କୋଉଠି ବ୍ରୋକନ ଚେନ୍ ରହିଲା ଥାର୍ଡ ଲୋକର କୋଉଠି ଏଣ୍ଟ୍ରି ହବ
if that child was taken to the hospital
କୌଣସି ଗୋଟେ ଯେତିକ ପାଞ୍ଚଟା ସର୍କମଷ୍ଟାନ୍ସ ମୁଁ ଆପଣଙ୍କୁ ଦେଲି can you say that it can be explained under any other hypothesis ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ପାଞ୍ଚଟା ଦିଆଗଲା ଆପଣଙ୍କୁ ଯେତିକି ଆମେ ପଢିଲୁ ଆପଣ you explain that a possibility of third party or possibility of explaining these circumstances can be ଆପଣ ଯଦି let us say ଗୋଟେ ସେଇ ଘରେ ଆଉ ପାଞ୍ଚଟା ଲୋକ ରହୁଥିଲେ ମୁଁ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ଦଉଛି ତାହେଲେ ଆପଣ କହିପାରିଥାନ୍ତେ ନାଇଁ ଆଜ୍ଞା ଏ ମା ଛୁଆ ସିନା ଦିଲେ ଆଉ ତିନିଟା ଲୋକ ବି ସେ ଘରେ ରହୁଥିଲେ ଏ ତ ନାହିଁ ହେଲା ତେଣୁ ବିଭିନ୍ନ ଜିନିଷକୁ ଦେଖିବାକୁ ପଡିବ ତେଣୁ ଗୋଟେ ଫ୍ୟାକ୍ଟ ରେ ଗୋଟେ କେସ୍ ର ଆନାଲିସିସ୍ କଲା ବେଳେ ଆକୁ ମଧ୍ୟ ଦେଖିବାର ଅଛି ତେଣୁ ବ୍ଲାଇଣ୍ଡଲି କୌଣସି ଡିସିସନ କୁ ଫଲୋ କରିକିନି ଇଏ କରିବେ
Mr. Tripathi, in the recent past also, this court has granted several judgments and acquitted on the ground of motive, absence of motive.
Yes, ma'am.
We have acquitted many cases, but those are all circumstances
But
you
in
have
the-
to see.
In the case of poisoning, also my lodge has
Yes, if the circumstance is such, that you have to see.
then
poisoning ro gote
if the doctor will in given premium report he will open the poison, then why SFSL is there, my lord?
No, why we cannot say that is, and see,
That is where
we have to get
report
it assured.
categorically stated.
We have to get it assured in a case where there is suspicion on the part of the in the opinion evidence of the doctor.
The apex court judgment is that it is sine qua non in case of poisoning.
Oh, then
SFSL report is
you'll give it. We'll see it.
but the thing is that the thing remains that you are not controverting that. You are accepting that it is a case of poison. Once you are not challenging the doctor's evidence and that doctor's even suggestion has not been given, and you are not taking a plea even if you are accused statement that ନାଇଁ ମୋ ଛୁଆ ଗୁଡାକ ବିଷ ରେ ମରି ନାହାନ୍ତି ସେମାନେ ଅନ୍ୟ ସାପ କାମୁଡାରେ ମରିଛନ୍ତି କି ଅମକ ଏଇ ଜିନିଷ ଆପଣଙ୍କର ମଧ୍ୟ ନାହିଁ.
Intrinsically, that container was also not.
No, you are denying even your own treatment. You are saying that I do not know. When the question was put that you have been given treatment, you are saying I do not know. So this shows your conduct that you are trying to completely avoid this situation. History of organophosphorus poison at her home and is brought by the attendant. On examination, patient is semi-conscious, pupil by literally constricted, swelling present. So symptoms are very specific.
ଏଥିରେ କହିଯିବେ କେମିତି କଣ ତା symptoms ସବୁ ହବ.
Repetition present, twitching of muscles present, suspected organophosphorus poison. So doctor is specifying. Yes,
ଏଗୁଡା ସବୁ ଲେଖା ହେଇଛି ତାର symptoms ହଉଛି ଏଇଆ. And
the doctor also knows that is the sufficient cause to cause that death.
Have you?
It might be cause result of.
Have you find out into search that it cannot be detected without C examination organophosphorus? No, not decision. Don't do decision. Medical science.
I will go through.
Even if negative visceral report also does not necessarily mean that the no poison. Meaning negative visceral.
ସେଥିରେ ଆସିବନି
ଏଥିରେ ଅଛି
ଆଚ୍ଛା we are
ଆଚ୍ଛା with that
ଉପରଟା କ୍ଲିକ୍ କର ତାପରେ ଇଏ କର ଟାଇପ କର বলা স্পেলিং বলে দাও কয়জন লেখো টেস্ট এন লেখো উইদাউট ভিসেরা টেস্ট লেখো উইদাউট বাস ভিসেরা বানান বানান দিলে হয় কোনোটা আসছিল ঠিক করো detection detection without viscera culture without viscera test but click করো So, Tripathi, and also I go through this. There are several papers on that. Whether the without viscera test, whether you Google le search kala asuchi without viscera test whether organophosphorus poison case can be detected or not. ହେଲା ସେଇଟା କ୍ଲିକ୍ କଲେ ଆପଣ ସେଇଟା ଯୋଉ କହୁଛନ୍ତି ଯୋଉ ଡିସିସନଟା ସେଟା କୋଉ ଡିସିସନଟା
এটা relying on apex court judgment, my lord has passed this.
ଶୁଣ ସେଟା କଣ ଦେଖିକି କଣ କହୁଛି
এটা ଅଲଗା poison, organophosphorus.
ପଏଣ୍ଟ ଅଲଗା
Page 14, my lord. 14 para 9.
ପଢିଲେ କଣ ଲେଖେ ଅଛି ଆପଣ ପାଖରେ
Mal.
सात नौ 2023 କହିଲେ ରିପୋର୍ଟ
Shall I place it, ma'am? Adverting to the contention raised by the learned counsel for the respective party, since it is the prosecution case that the deceased died on account of poisoning, we have to first divulge into such aspect. The relevant witnesses are the doctor, that is PW5 and CW1 and CW was the medical officer attached to Chandanpur CSC. He stated that the deceased came to the CSC on 26/1/2006 and he was having convulsion and he referred the deceased to district headquarters hospital Puri. He further stated that since there was no referral slip, he could not say what treatment was given to the deceased when he attended the deceased on 26/1/2006. His evidence is completely silent that he even suspected.
You see this line of difference.
Refer to be poisoning for which there was convulsion and accordingly he referred the patient to the DHS. The doctor who conducted the postmortem examination of the dead body of the deceased stated he could not detect any external injury on the person of the deceased and since no definite opinion could be given, he preserved internal organ of the deceased like spleen, liver, stomach with their contents and
now you see the basic difference between the factual aspects of these two cases.
My lord.
Right?
My lord.
ସେଇଥିପାଇଁ ଆମେ କହୁଛୁ ଯେ ଟିକେ ଏପଟ ସେପଟ ହେଲେ ମଧ୍ୟ ଇଏ ହେଇଯିବ
I will see this person, my lord, that whether organophosphorus without viscera ଜଣା ପଡିବ କି
ଦାନାଦାର ଗୁଡାକ ଆପଣ ତ ଜାଣିଥିବେ ଯୋଉ ଏଇ ଚାଷୀ ଗୁଡାକ ଯୋଉଗୁଡାକ ସବୁ ରଖନ୍ତି ଘରେ ଯୋଉଗୁଡାକ ତାର ଚାଷ ପାଇଁ ତ ୟୁଜ ହୁଏ ନା ତ ସେଇଗୁଡାକ ଅଧିକାଂଶ ତାକୁ ଖାଇଦେଲେ ତାର ଗୋଟେ ସିମ୍ପଟମ୍ସ ଆସିବ ତାର ଦେଇଛନ୍ତି ମଧ୍ୟ କେତେ ମାତ୍ରାରୁ ଇଏ କରିଦେଲେ ଇନଟେକ୍ କଲେ ତାର most of the cases ଏଗୁଡାକ ଯୋଉ ଥାଆନ୍ତି ସୁଇସାଇଡ କରନ୍ତି ସେ ଦାନାଦାର ଏଗୁଡା ଖାଇଦିଅନ୍ତି
ଏଇଟା ହେଇଛି କଣ ଏଇଠି ଏଣ୍ଡୋଲସନ୍ ଇନସେକ୍ଟିସାଇଡାଲ ଅଛି
other poison.
ଏଇଟା ଅଦର
But in that both the judgment which lordship was referred, where it has been written that viscera reporting silent one.
No, ଏଠି କାହିଁକି ନା
ଫ୍ୟାକ୍ଟ କାଇଁ
କିଛି ନାହିଁ ଏଠି ମାନେ ଏଠି ଦେଖନ୍ତୁ ରେଫରିଂ ଡକ୍ଟର କହିଲା ମୁଁ କିଛି କହିପାରିବି ତାପରେ ସେଇ ଯୋଉ ଡକ୍ଟର ସିଏ କଣ କଲା ନା ତା ଏଭିଡେନ୍ସ ବି ସାଇଲେଣ୍ଟ ସିଏ ରଖିଦେଲା କଣ୍ଟେଣ୍ଟସ ଗୁଡାକ ରଖିଦେଲା ପ୍ରିଜର୍ଭ କରିକିନି କାହିଁକି ନା ସେ ଆୱେଟ୍ କଲା କେମିକାଲ ଏକ୍ସାମିନେସନ ରିପୋର୍ଟ ସେଠି କେମିକାଲ ଏକ୍ସାମିନେସନ ରିପୋର୍ଟ ଆସୁନି ହେଲା ତେଣୁ କଥା ହେଲା ଯେ ଏବଂ ଭିସେରା ପାଇଁ ପଠା ହେଇଥିଲା ତେଣୁ ଡାକ୍ତର ଯଦି ପ୍ରଥମରେ ପୋଷ୍ଟମର୍ଟମ ଭିତରେ ବେଳକୁ ସିଓର ନୁହେଁ ଏବଂ ସେ ଡାଉଟ କରିକି ନିଜେ ସିଓର ନୁହେଁ ସେ ଭିସେରା ପ୍ରିଜର୍ଭ କରି ପଠଉଛି ଏବଂ ଭିସେରା ରିପୋର୍ଟ ଆସୁନି ସେକେଣ୍ଡ ଟାଇମ କହିଦଉଛି ଯେ ନା ଇଟ୍ସ ଏ କେସ୍ ଅଫ ପଏଜନ ତ ସେଥିପାଇଁ that is the difference. Neither the I was stated that he collected the visceral report nor sent it to the PW5 nor PW5 has received the visceral report and given his opinion as to the definite cause of death. तादर भी ये भी नथिला definite cause of death.
89. It may be cause of death. Definite cause of death नहीं. I will give a
It's
decision,
surprising
my
how
lord.
the doctor gave such opinion, how the learned trial court came to a definite conclusion that
Yes,
the death of the deceased
that
was
is there,
due to
my
the
lord. And there is another judgment also I will give, my lord. When there is not sufficient cause to death, 30 is not maintainable. This judgment is there. I will give. Sufficient cause to cause the death যদি নথিব PM report রে, then 302 is not maintainable. This
କଣ ଅଛି କି ଏଠି?
ଏଥିରେ ଲେଖିଛି the cause of death of the victim might be due to organ failure. Sufficient cause ଦେଇନି. This is sufficient to cause the death. Lordship, page 40, your lordship, kindly have a glance. PW 9. Last para.
Even other than that, what happens in a case when it is seen right from the beginning, the nature of evidence is absolutely weak. So here you see the extrajudicial confession is not up to mark. The oral dying declaration stated to have been made by before PWT and the deceased has not whispered anything against the appellant. So the appellant against भी किसी नहीं. So those aspects have to be seen.
ଗୋଟେ ଜିନିଷ ହେଇକି in addition to that ଏଇଟା ହେଇକି ଦିଆହେଇଛି. ଆଉ ଗୋଟେ ଏଇଟା ଦେଖନ୍ତୁ ସେଥିରେ actually investigating the analysis ଟା is from page number 23. Page number 23 ବସିଛି. 1, 2, 3, 4, 5, 6. 6 lines from the bottom. In her cross examination. Hold on.
Rule 2 has stated.
Right. This judgment which you are judgment raw page number 23.
23.
The total lecha is 23 out of 30 of 32.
Well, in her cross examination, PW2 has stated that she had given a little, then a half glass of milk to the appellant to drink, and the appellant drank half of the milk given to him, and after taking a sip, complained of bitter taste and did not drink any more. And after keeping the glass with the rest of the milk, complained smell of petrol and kerosene in the milk and left her house. The evidence of PW2 revealed that after the deceased complained taking a sip of the milk, not only she but
Just mark it.
not only she but also her daughter-in-law tasted milk and they also found that it was bitter. But there was no evidence that there was any reaction after taking the milk by either PW2 or the daughter-in-law. The daughter-in-law PW2 has not been examined in this case. If the same milk was taken by not only the deceased but also PW2 and her daughter-in-law, nothing happened to them. No visceral report was produced on the basis of opinion of Dr. PW5. Without present a visceral report, the learned trial court should not have come to the conclusion that probable cause of death was due to poison. It
See the analysis has been there. So, all right, we'll take up this matter tomorrow or
one day after.
Wednesday.